Lordship. May I kindly be permitted to mention, Lordship, upon notice, Lordship, it is item 342 of today's list,
This is
Lordship.
the first page of my list.
Lordship,
Why
Lordship,
are
there
you
is,
still mentioning that?
Lordship, there is an urgency, Lordship.
You have to, urgencies have to wait for some.
Lordship, may I permit it?
If I
Restore.
and it again goes down to 300 and something, will it help?
Lordship, it is already in the
Not in my list. Give
mentioned
me some
matters.
time.
Lordship, it is in the mentioned
Lordship, may I permit it to mention 1-2 matters analogously for restoration application, Lordship.
Restoration.
Restoration.
Upon notice.
Upon notice,
Give it.
Lordship. Grateful, Lordship.
Contempt application for accident.
Content application, please give the number.
Yes.
My lord,
Deeply obliged.
Restoration, give the number.
my lord, may I permit to be mentioning, my lord, upgradation, my lord, item number 504.
Yes, you can mention, but before you mention, please see the first page of my list.
My lord,
To mention, you can.
my lord, restoration application. My lord.
Yes, upon notice.
My lord, মেনশন করব আমি একটু আমার ব্যাটারটা
আমি মেনশনিং নিচ্ছি না এখন, আপনাকে কিছুদিন অপেক্ষা করতে হবে। Yes, call the days list, please. Item 1, 1 not this week. Item 2.
for the petitioner, my lord.
I am for
Is
the
there-
state, my lord.
My lord, it's for the restoration application.
Restoration
Restoration application. Dismissed on 5th February, my lord. We have
within time.
Huh?
Within time.
within time. 16th February, we have filed this application, my lord.
Your appeal.
Yes.
Are we ready with the writ petition? Can it
Ye-
be considered
yes.
now?
Yes, my lord.
Yes, what is the matter about?
My lord, this is a matter. My land has been acquired. Admittedly, my land has been acquired, but no compensation has been paid. Everything has been complete, my lord. AOAR, everything has been.
It was, the acquisition proceeding had lapsed.
Lapsed. My lord, 2015. My lord, 2015, the land has been acquired.
It's not really acquired, it was utilized.
No, it has been acquired, but no compensation has been paid. By RTI later, we have found that the
Do you
land has
have
been.
a representation pending before the authority?
No, my lord,
You
nothing.
have not filed a representation.
We have asked from the department through RTI that land has been acquired, but no compensation has been paid.
So why don't you submit a representation before the authority which may be considered within a stipulated time frame?
So, my lord, the representation was been done, but that has been rejected, I think. So.
Yes,
The representation was made, but not considered.
but not?
Considered, my lord.
Where is the representation? That's what I'm asking.
My lord, in the my lord, kindly come to page number, my lord. There is the representation. My lord, kindly come to page 44, my lord.
Page 44.
Of the writ petition, my lord. No.
44 cannot be the representation.
My lord, my lord, my application date is when my application.
44 is annexure D. It's not a representation, it's a communication.
No, it's a communication by we have approached.
It is from the additional land or acquisition officer to you. It's only a communication. Where is your representation asking for compensation?
My lord,
That is your case.
I have to
isn't it?
ascertain, my lord. I have to ascertain.
Will you file a comprehensive representation before the authority? Stating entire facts?
My lord, kindly come to page number 45.
45 is a list of documents.
Everything has been given, my lord, but not considered. Then, my lord, kindly come to page number
What
40.
will be considered? Where is your representation to be considered?
My lord, no
You have to give
representation.
an application to them, isn't it, for consideration? Where is that?
That I have not annexed.
The application
That we have not. Kindly give me a liberty, my lord, to.
That's what I'm saying. Instead of keeping another date, why don't you file a comprehensive representation annexing all relevant documents? The authority will consider it within a stipulated time frame.
Deeply obliged, my lord.
That will save
Deeply
time.
obliged. Deeply obliged.
Yes,
Yes,
you
ma'am.
agree to this?
Yes, ma'am.
Can 1 of 2024 unfold?
আমাদের
This is
আমাদের
an application for restoration of the restriction which was dismissed for default by an order passed on 5th February 2024. Paragraph, sufficient grounds being made out, comma, the application is allowed. Paragraph, the order passed on 5th February 2024 is set aside. Paragraph, the writ petition is restored to its original file and number. Paragraph, there shall be no order as to costs. Can such and such is disposed of. WPA te order করুন. The writ petition is treated as on days by consent of the parties. The writ petition is treated as on days list. Paragraph, heard learned counsels for the parties. It is submitted on behalf of the petitioners that the land of the petitioners was acquired by the respondents, but no compensation has been paid to them in this regard. Stop. The petitioners seek to submit a comprehensive representation before the concerned authority in this regard and pray for a direction upon the authority to consider the representation at the earliest. Paragraph, learned counsel for the respondents submits that the special land acquisition officer,
Yes, ma'am.
the fourth respondent, be directed to consider the representation in accordance with law. Paragraph, in view of the above, the writ petition is disposed of with liberty to the petitioners to submit a comprehensive representation before the fourth respondent, annexing all relevant documents in support of their claim within 2 weeks.
Within 2 weeks.
Within 2 weeks from date. Stop. The fourth respondent is directed to consider and dispose of the representation within 1 month.
Yes.
Within 1 month from the date of receipt thereof, upon affording reasonable opportunity of hearing to all concerned, including the petitioners, comma, in accordance with law. Paragraph, the decision taken by the authority be communicated to the petitioners within a week thereof. Paragraph, in the event the petitioners are found entitled to compensation, comma, the fourth respondent shall take all consequential steps for disbursement of the same in favor of the petitioners within 2 months thereafter.
In the present act, my lord, kindly. In the present act, they will consider this.
Tiger representation, state this in your representation, let them consider.
Comprehensive representation. Yeah, okay.
Item 3.
Yes,
My lord, this is my application for review. This is my particular service.
Mr. Ghosh is appearing.
My lord, I am for this.
Now, my lord, this is the review for the purpose of, my lord, to me, some date has been, my lord, regarding the wrong calculation of the, my lord, the amount. Your lordship, if your lordship kindly turn to the,
The order under review.
yes, that is that page, my lord, that a review order of your lordship's order dated, and my lord, 14 July 2023. Now, while dealing with the writ petition, my lord, if your lordship kindly turn to, my lord, the inner page 2,
Yes,
my lord, last 4-5 lines, my lord, revisional application. What starts from revisional application?
yes.
My lord, divisional application being show number was preferred by the Metro Railway Authority against the order of the appellate forum before this court, and by an order passed on 7th February, a coordinate bench of this court set aside the order of the appellate authority and direct the appellate authority to reassess the amount of compensation payable to the petitioner herein in the light of the observation made in the order. In compliance with the said order, the respondent reassessed the compensation payable to the petitioner interior, holding that the petitioner was entitled to a sum of rupees 3,70,92,000 on account of compensation. The respondent filed an application for review of the order dated 28th passed by the appellate authority, which was allowed, thereby reassessing the compensation amount at rupees 15 crores something in place and stead of 16 crores. and the Metro Railway was directed to pay a sum of rupees 2 crores to the petitioner being the unpaid amount. The said amount was received by the petitioner without prejudice to his rights and contention. The petitioner also received a sum of rupees such and such from the authority by a check dated 5th September 1980 as the admitted amount then. The learned county petitioner, then my lord, I have relied on the circular. Then my lord, lordship kindly turn to your lordship's order at page 8.
8,
Page 8,
yes.
11, paragraph 11.
Yes.
It transpired from the judgment of acquisition claim case, the award in lieu of acquisition of the land of the petitioner is declared on 16 December 2016. The petitioner, by a letter dated issued to the General Government of Calcutta such and such, informed the later on that possession of the plot in question was taken over by the main agents of respondent. This letter was received by the respondent on the same day. Then, my lord, possession was taken over, my lord. Your lordship was also held the 21st February 2017. Then, lordship kindly see the last portion. The amount of compensation was assessed and reassessed by the authority as recorded earlier, and the admitted amount of compensation to the tune of rupees 12 lakhs was paid to the petitioner only on 30th August 2018. No compensation on any part thereof was paid or deposited by the respondent prior to that said date. Total amount of compensation finally determined at 15 crores something, and the balance amount 2 crore was paid to the petitioner 11 June. Therefore, it is crystal clear that the possession of the land was taken over on 21st February 2017. Compensation was paid to the petitioner only on 30th August 2018 and 11th June 2019. The petitioner is therefore entitled to interest on the amount awarded in terms of Section 80 of the 2013 Act at the rate of 9% per annum from 21st February to 28th February 2018 and 15% per annum on from 21st of February to 30th August in so far the amount amounting to rupees such and such is concerned, and from 21st February till 11th June so far as the award amount such is concerned. But I have prepared a subject to your lordship kind consideration. এটা দিদি একটু জজ সাহেবকে দেবেন
একটা কপি করে
তুমি যদি ইনস্ট্রাকশন দিতে চাও দিতে পারো
You want me to add this calculation in the order?
my lord, this is the my lord, claim, my lord, that I am entitled to. But according to me, I have a
Yes,
copy.
but this review will not be maintainable. You are aware, Mr. Khan.
That-
The order cannot be reviewed on this ground.
my lord,
Calculation has been stated as the percentages are given.
yes.
And this is according to that percentage. You
Only
have
the
made a
date,
calculation.
my lord, certain dates are there, my lord, which should be my lord, subject to your lordship correction. Since my lord, your lordship had said that 21st and 20th February, it is correct. And 21st February to this should be my lord 4th of September 2018. Because 5th September
4 days, Mr. Khan. 4 days.
my lord,
I have
may
to
I
dismiss your review application. This cannot be a
my lord,
ground for review.
my lord, may I say one and then just before while dismissing my application, instead of dispose of this thing, my lord, with a liberty to
I
make
can
a
grant it for
comprehensive to, I will draw the attention of the authority concerned to,
In a review application, you are aware I cannot do anything.
no,
You can at best withdraw the review application. I have to dismiss it otherwise. That will not inure to your benefit, I think.
Well.
Isn't it?
Well.
If I dismiss, the authority will say the court has not accepted this.
yes, that's correct,
Though that is not a fact,
yes.
the authority will only be happy to say that. So I think it will inure to your benefit if you just withdraw this. I'm not going to make it settle. Mr. Ghosh? Yes?
Your lordship order is very specific. And my lord, there is no my lord.
Khan wanted me to record the figures also. the
Yes,
amount.
yes.
Well, I will
You can take this. Didi, এটা ফেলে দিও। Learned affidavit of service. Review টাতে order হবে, হ্যাঁ? Affidavit of service. Learned counsel for the petitioner seeks to withdraw the review application. Paragraph in view of the above. Review application being RVW such and such is dismissed as withdrawn. There shall, however, be no rest to costs as is referred by second.
গেটফুল
Next.
আরে অ্যাপিয়ার করলে তাহলেই নাম দাও, এরকম ভাবে করো না, আমাকে লোকে গালাগাল দিচ্ছে।
Appearing for the first time for
Appearing for
violation
the
of
first time, will you serve and come back?
minor.
The applicant petitioners are directed to serve copy of the contempt application along with annexure thereto, annexures for the annexure thereto upon the alleged contemptor and file affidavit of service on the adjourned date. Paragraph, let the matter appear under the same heading on 15th April. Next,
This is also same.
same order, same date.
Macho.
But I am appearing for the petitioner, my lord.
Appearing for the first time?
No, second time.
Have you served?
Yes, I have, sir. The lordship kindly see the page 45.
The service.
Judgment of your lordships.
Sir,
Page
Mr.
45.
You're
My lord, yes, my lord. I'm my lord. Only thing, my lord, my lord has passed an order.
only be complied or
No,
not?
complied. So for our part is concerned, we have complied. My lord knows that my lord has passed an order directing respondent number 1, 2, and 5. 1, 2, so far 1, 2 is concerned, my lord, they have complied. So far 5 is unless placement, my lord knows, my lord has, my lord, passed so many judgments regarding that. You place the fund, directing the PWD secretary, place the fund so that it can 6 crores. My lord, we have intimated, my lord, just now, my lord, we have intimated the principal
Affidavit.
secretary, 6 crores
Affidavit.
affidavit because it is not a the rule has not been issued. That's why, my lord, I pointed out so that my lord will understand. So far, our part is concerned. My lord knows that, and my lord has passed various orders that directing the principal secretary of the PWD, the authority who has utilized the land, they must first pay the money in favor of me so that I can disburse. Everything has been done. 6 crores.
5 has utilized. Respondent number 5 has utilized.
No,
the
my lord, the service.
Yes,
the-
5. আরে বুঝতে পারছেন না PWD utilize করে।
Yanni
You are
of
appealing
that.
for all the three.
My lord,
contenders?
them is the chairman of the purchase committee.
আরে
Yes.
টাকা না পেলে
But talk of fund, their internal problem, my lord.
That in the no, my
This is
lord,
not my problem.
কোনো
My land
problem
utilized,
নয়, শুনুন,
it is fact.
জজ সাহেব এরকম অর্ডার দিয়েছে যে ওদেরকে ডাইরেক্ট দিয়েছে প্লেসমেন্ট তারপর হয়ে গেছে। দিস ইজ দ্য লেটার আই হ্যাভ ইস্যুড, my lord. Yes, special secretary. Can you see? আরেকটা দিন। তোমাকে একটা copy।
আরে এটা তুমি কি এত বড়?
এখানে সমস্ত যে আমরা যে কাজ করেছি।
না কাজ করেছো ঠিক আছে। আমার কথা হচ্ছে এত বড়।
And my lord, here the my lord kindly come to this part also. It is not any no, it's not
Who will place the fund? The special secretary will place the fund.
the PWD. My lord, this is the amount. Among, my lord, only thing kindly identify, kindly pass an order. There should be a reflection from the order itself that out of 72, that other plots of land also, my lord, that is that was unauthorizedly, I should say unauthorizedly utilized by the PWD. That was also included in the valuation, and the valuation is, my lord, 6 crores 70
All
lakhs.
this cannot be recorded in in an order in a contempt application. You file your affidavit of compliance.
My lord, compliance, my lord, unless, my lord, my lord, my lord,
I'll record your submission
yes.
and I'll see that the special secretary.
Special secretary may be directed, yes. Directed that so that fund can be placed to the DM, but that is the container number 1. Right.
Affidavit of service. Paragraph, it is submitted on behalf of the alleged contemptor
No, no, copy
that in compliance with the order under contempt, comma, the special land acquisition officer, comma, HON'BLE has written to the special secretary to the government of West Bengal, comma, Public Works Department within bracket roads wing, bracket closed, comma, land acquisition branch on 5th March 2024
my lord, and this portion can be included because 6 crore 70 lakhs what the valuation on the basis of the present ADSR report, my lord, it includes other portions of the land.
Not be included in
Yes,
this
yes.
order.
So, my lord,
That
this
has to
part,
be
this is there.
I will just ask.
No, my lord, kindly record that. Otherwise, my lord, because so far our party is, my lord knows that so far our party is concerned, we have complied. We have valued, we have estimated on the basis of the report of the ADSR, concerned ADSR, and report
Record is
suggests,
sufficient.
kindly sir, record my
Requesting placement of fund
amounting to rupees, my lord, 6 crore 70 lakhs, my lord,
tune of rupees 6 crores
70 lakhs 85,341.
6, 70, 85, 340.
341,
341.
which includes
6
other
crores-
lands,
Second amendment, huh?
which includes lands which does not belong to petition. But others lands also include. Otherwise, they will claim that 6 crores that
Which
is there.
includes land
Other than
other than the one belonging to the petition.
petitioners, yes. And my lord, direction may be issued to the principal secretary of the PWD should placement of the funds. My lord's direction, my lord, the order within such and such date to the in the office of the DM.
The matter is awaiting placement of fund by the special secretary to the government of West Bengal for disbursement of the same in favor of the
DM, my lord,
applicant
the container number,
by the
container number 2.
second by the second contemner, second alleged contemner, comma,
Within such and such date. When otherwise, my lord, we will be in trouble.
I cannot direct, I'll state that it is expected
Expected.
because he is not a contemner.
Yes,
here.
yes.
It is expected that the special secretary shall place such funds before the second alleged contemner at the earliest, comma, preferably within 1 month. 1
2
month.
months, my lord, better
No, no,
so
no,
that
no, my lord.
1 month, no, my lord, what I am.
Again, my lord, they will come.
তুমি তো টাকা পাবে তো basis 1 month, then my lord placement after that, my lord, that so that payment they can realize the payment.
Payment another 2 weeks after
Yes,
that.
yes.
1 month and 2 weeks.
1 month.
1 month from the date of communication of this order. Stop. The second alleged contemner is directed to disburse.
My lord, I have 4 weeks, my lord. I am beseeching 4 weeks. 4 weeks,
You
not 2
just
weeks.
disburse.
Because no, my lord, ownership now they have to place their title regarding ownership because it is mandatory as per the yes.
কি বললাম?
4 weeks.
Such amount in favor of the petitioner, applicant petitioners within 3 weeks from the date of receipt of the fund
Upon showing, my lord.
upon the allow me
Showing.
to dictate. Mr.
I
Chairman.
just
Come
said-
back to your original form. Upon the petition, the applicant petitioners producing relevant documents before the authority in support of their claims.
My lord, one
Let
thing,
the matter appear under the same heading on today's 13th. Today 13th, another 3 weeks. 7th May.
And my lord, may I beg another, my lord, may I beg another
Affidavit of
Yes.
compliance be submitted on the agenda.
my lord, may I beg affidavit compliance to be submitted by the, my lord, the principal secretary of the, my lord, PW as well as because contemners, they
Contemner at all.
my lord,
all, but my lord, he has to be because as
By
per
the
the
contemner,
Well,
saying that
well.
we have disbursed.
my lord, may I one thing, my lord? Your lordship judgment reflects the petitioner, including all other interested persons.
No, that is
And
the
has been
same.
affected
No.
for the construction of.
No, it can't be.
This is reflection of your lordship's own order.
Can't be. পড়ো ঠিক করে আমিও পড়েছিলাম ওনারাও
Page
পড়েছিল।
46, my lord, bottom.
Yes. Upon consideration of the submission made on behalf of the parties and material, the writ petition is disposed of by directing first, second, and fifth resolution to initiate the process of the direct purchase of the plot in question at the earliest and take necessary conclusion of the same within 4 months from the date of communication of the upon affording reasonable opportunity of hearing to all the interested parties.
Including
Interested
petitioner.
parties means stakeholders.
Hearing.
So
The
how can it
stakeholders.
be? My lord
Not
cannot pass.
interested person, including petitioner.
Interested persons not for disbursement, for hearing.
Yes,
Disbursement.
but
only to the
yes.
petitioner.
Hearing was given.
Stakeholder.
If I am entitled to, I am entitled to.
This is
No
fine.
problem.
This is all right.
Madam,
কোনোদিন
may I,
বাদ দেওয়া যাচ্ছে না।
may I communicate the order including the contempt petition?
Why? He is represented. The contemnants are
Well,
represented.
let him do so.
No, why? Not necessary at all.
I'm grateful, madam.
Mr. Shimbu,
This is
Well,
contempt. This is
But
contempt of the
subsequently, they will come and say, we won't get any copy hand.
won't get copy.
Mr.
Order হয়ে গেছে তো,
Mr.
আমার তো
Shimbu will
copy.
be responsible for it.
I'm grateful.
He is representing all of them.
I'm,
Copy হবে।
Why will you take the pain? Not necessary.
I'm grateful.
Obliged, madam.
Next.
This matter I am appearing on behalf of the petitioner. This is my affidavit of service.
My lord, I am appealing for the contempt matter.
This is my affidavit of service.
You are appearing for the
Madam.
contemnants?
My lord, the problem is here, when the order being passed, directing the HDO to give them the hearing, then pass a written order.
Yes.
That time, the HDO was Mr. Kaushik Chatterjee. He has held a meeting. My lord and client appeared in all the 3-4 meetings appeared. Order being passed. Decided this is unauthorized construction. Then according to law, because the under section 5 of the unauthorized construction, my lord, so there is appealable order under section 7.
Yes.
Now that order directing the PW, the respondent number 6 to take steps to demolish. Again, that order appeal is being filed. In the meantime, 31st October, the Mr. Kaushik
Has retired.
has
Has
transferred. In his place, Madhumita Mukherjee is there at the moment. My problem is, my lord, again the contempt petition being filed, again the Madhumita should not be. This is not, does not arise, my lord. Because when
from what
the
you are saying-
application,
From the submission that you are making,
Magadi,
order
no,
has
no, no. The problem is with me today, because from last night she is having a, very high temperature.
no, I'm
The
not on
officer has come,
I am not on that at all. From what you are submitting, the order has been complied with.
complied with.
After that, an appeal has been preferred.
But below, that is from the annexure of the
So where is your
petition
appeal?
itself, it is there.
No,
They have annexed that order.
That is not the true. My lord, straightway come to page 36. Page 36, that is
My
the
lord, I am also referring the 36.
36.
That is the second page, my lord.
That order was passed on 17/10/2023.
Yes.
Relevant portion is paragraph 5. Therefore, on being satisfied, after measurement and everything is complete thereafter. Therefore, on being satisfied from the findings of the inquiry team, in exercise of power conferred under section 4 of the said act, I do hereby direct the said Bhagirath Mandal to vacate the government land encroached by him as described in paragraph 3 within 15 December 2020. That is the final order was passed, in my view. Thereafter, not execution order.
Have
Not
you heard
at
the
all.
submission?
My lord,
This
sir.
order has been carried in appeal, which is pending.
Appeal.
They are appearing. That is-
Kindly allow me to say, sir. There is no such interim order. That is the page 42. Page 40 and 42.
Can
I
there
have-
be a demolition during pendency of the appeal?
Yes, my lord, the no interim order was passed. They have
Maybe.
prayed for interim order. No interim order was, that is the refusal. Thereafter, the order was passed. That is the last
Mr.
order.
Das,
That is the
the-
last order. That is the
maybe
31st
that
March.
is in the appeal. This court is not concerned with the appeal at all.
Yes.
So the order of the court has been substantially complied with.
No.
Your
no.
representation has been considered.
Consider they have passed an order that will be demolished on 15th December. They have not demolished. They have not
Due to
demolished.
pendency of the appeal.
They have not demolished.
Nothing
Thereafter,
further in the contempt
my
application.
lord, kindly allow me for some time, my lord. Thereafter, they preferred an appeal. An appeal court interim order was not passed, refused.
Maybe.
That means that order is stand, that must be complied. That must be
Mr. Das.
during mere filing of the appeal, without issuing any interim order, refusal the interim order by the court below, thereafter no bar to execute this order. That is my whole submission, so my
That
lord.
is another aspect.
So, my lord, that is what is the observation? That is first of all, that is findings.
What is
After
the
inquiry
order
of,
under contempt?
yes, my lord, kindly state a
Disposal
company.
of the representative.
Yes, no.
That has been
No,
done.
that is not considered this is case. This is the third round battle. This is after all, that is a findings, my lord, state a come to the order.
The order of the date of the order টা আমাকে দেখানো একটুখানি, আমি তো কাছে নেই, একটু দাও না কপিটা।
Page 23. It was the last order, that is the last
If
order.
there is no stay, please advise your client to carry
No,
on
no,
the
Malik.
order.
Thereafter, they have passed an order that kindly they give me this.
না ফার্স্ট
That-
অর্ডারটা
Yes, page 23. Page 23. It is a very serious case, my lord. Page 23. Pursuant to an earlier writ petition being W such and such filed by the petitioners compelling illegal encroachment of government land by the private respondent, and an order passed by this court on April 20, 2022, directing the concerned respondent to consider a disclosure representation submitted by the petitioners in this regard, February 2, 2022, within a period of 3 months from the date of communication, upon affording reasonable opportunity of every volunteer party. The assistant engineer Salboni, any subdivision PW roads directed by an order passed on September 1 to observe that there is an illegal
Please come to the
construction.
last line of the order. The last line of the order.
Last line, that is the date mark is the 31st March. They
So
have
it is
executed.
premature.
That no, they have passed an order thereafter, 31st March 2024. That order will be executed. That was communicated day before, only day before. Long before this contempt application was filed, they have passed an order that will be demolished in 31st December. Thereafter, appeal was filed. No interim order was passed. Refusal. Then I have prayed for to execute it. Then last of all, on 12th March, that order was shut, that I will execute on 31st March. 31st March,
Order has been substantially complied with.
no, there is no question of compliance with my lord. Kindly, no question of compliance, my lord.
There is, no,
My lord,
it has been complied.
kindly allow me for some time. My lord, kindly. My lord, page 24.
Let us not spend more time.
My lord,
Mr.
page 24 for a moment. First of all, it is a PW land. Government is this is a encroachment of the government land. Subsequently, thereafter, the new act, that is the public.
But in new act,
New act means that is the Public Demands Recovery Act.
Yes,
That was
page
also
24.
finding that is the encroachment. That government must be complied.
What is the operative portion
Yes,
of the order?
order,
under
my lord.
contempt?
Yes, my lord. Within since encroachment of the government land has been recorded. That is the page 24. Since the encroachment of the government land has been recorded by the assistant engineer Salboni, any subdivision, PW roads directed. In this order, passed an order September 1, 2003. The writ petition is disposed of directing such and such. That is this. What is the such and such? That is submitted by the petitioner dated December within a period of 2 months from the date of after giving reasonable opportunity to all parties and private respondent in the light of the observation. That is the stigma made by the assistant engineer Salboni in his division PHW directed in his order dated September 1, 2003. In accordance with
So
the
this has been
objection.
complied with.
Yes, my lord. That so what is the order? What is the order? That is page 36. That is the page 36.
Yes.
That is
so
the
it has
order.
been complied with
Yes,
the terms of
compliance.
the
What is
order.
the order? I am asking myself, my lord. Page 36. Therefore, on being satisfied, page 36. What is
Yes.
their order? Therefore, on being satisfied from the finding of the inquiry team, in exercise of the power conferred under section 4 of the said act, I do hereby direct the said Bhagirath Mandal to vacate the government land encroached by him as described within 15 December 2023. That order must be executed.
You are repeating, Mr. Das. I'm
My lord,
sorry.
that
Please do
order
not
must
repeat
be
your
executed.
submission.
And the last occasion, my lord, where shall I go? That is the clear findings.
Premature. And the order under contempt, this is a contempt application, not a writ petition.
Yes, contempt application.
Contempt application scope is very limited. You are aware.
My lord, again, first of all, my lord,
Heard by the
kindly allow
counsel,
me for
please.
some
No, it's-
time.
I have heard you.
My lord,
Heard by the
third time I
counsels for
will
the
come
parties.
before you.
My lord,
Paragraph, it is submitted on
third
behalf
time
of
sir,
the
I go to,
subject
my lord, I go to report by the present
that is a PWD room.
SDO, my lord. Just keep it in the record.
My lord, kindly,
Report
they have,
submitted on
they
behalf
have,
of
they
the
have taken a time.
alleged
They
contempt
have
is
also
taken on
taken a
record.
time on 30th March
তারপরে learned counsels for the
2023.
parties. প্রথমে রিপোর্টটা করুন, তারপর ওটা
Kindly allow me, kindly allow me.
I have heard your
My
submission.
lord,
Please do not- you are
kindly allow me.
You are repeating your submissions.
No,
This
my
is
lord, I am not repeating.
essential at all.
My lord, I am not repeating. They have passed an order that will be complied with.
You are repeating, sir. Please do not do this. It is submitted on behalf of the applicant petitioners that pursuant to the order under contempt, comma, the subdivisional officer, comma, Medinipur Shodor considered the representation submitted by the applicant petitioners and by an order passed on 17th October 2023, comma, directed the encroacher to vacate the government land within 15th December 2023. So this was not a date for eviction. It was a date given to the encroacher for vacating,
Yes.
not an eviction date.
No,
As you were submitting all
no,
this
no,
time.
no, I am not eviction.
Stop. The encroacher preferred an appeal against the said order, but no stay was granted by the
They have
appellate
appeared
forum.
in the matter.
I am recording his submission only.
No, I sorry, my sorry.
It is only his submission that I am recording.
Yes,
Fine,
I
fine.
have
I'm very
finished the document.
Stop. The applicant petitioners submitted an application before the subdivisional officer for implementation of the order passed on 17th October 2023, which was disposed of by the subdivisional officer by an order dated 7th March 2024, which records that the order passed by him earlier should be complied with within 31st March 2024.
Yes.
Paragraph in view of the above, this court is inclined to hold that the order under contempt has been substantially complied with. Paragraph, the contempt application being CPA and such is accordingly disposed of. There shall, however, be no order as to cost as in certified website.
My lord, the report filed by the deputy.
My lord, that order should be kept in the record.
Yes.
And that order should be kept in the record.
Report submitted
Hello,
on
only-
behalf of
only-
the alleged contemners eto shurute, and copy of order passed by the subdivisional officer submitted by the applicant petitioners are taken on record.
My lord, in this application, my lord, the case number should be, that is 1881. That is the long.
Yes.
road.
File the info, আপনি ভুল করেছেন।
That is the
একদম শুরুতে-
WPA
Yes, yes. Thank you.
188.
একদম শুরুতে করুন। Inadvertent error has crept into the order passed on 7th February 2024. Paragraph in the said order, WPA 1021 of 2023 be read as WPA 1881. 1881 of 2023. Paragraph, the department is directed to incorporate necessary correction accordingly. Paragraph, this order be treated as part of the order passed on 7th February 2025.
No, only one humble submission. That is the order passed on 12th March 2023. That order will be executed on 31st March 2023. That should be complied with. Only this observation.
There is a direction for
Yes,
compliance
that
by
is
the
that is their
authority.
own order. That is
In
their
the-
own order. Again, I will be come before your lordship. Again, I will be come.
Understand that the appeal is being disposed of. That order cannot be passed at this stage.
It is your direction to comply with the
comply.
order.
Yes, my lord, I have.
And there is no stay in that.
No. I know.
So there is.
I
no
have spoken to
difficulty.
my client. No, I have spoken to my client also.
Ensure compliance of the order.
My lord.
by the date,
No,
31st March.
before discussing the appeal.
Of course, there is no stay order.
No, sir. Okay, my lord. I'm asking that.
And it is your order that
No,
it
my
is
lord.
complied with by 31st March.
My lord, then one line may add it because they have, it is the PWD is going to respondent number 6. One line be added there, my lord. The order of the order of the SDO, order of the SDO complied with by the respondent number 6.
Says that it will be complied with by 31st March. The court doesn't.
Yes,
need to
but
say anything
but
further.
the PW is to comply the order of the
Concern,
SDO.
it's your concern.
As you know.
Next matter.
My lord, one copy, my lord, I will send the Xerox copy. That is the
It is
single copy. I will be just now, you will be give me.
Of
That
the
is
order.
Order. That is the 23rd.
Please give us Xerox because I've recorded it.
Xerox, yes, they record it. I will give you. Only one copy. I will send it and Xerox.
দিদি এই কপিটা কিন্তু উনি জেরক্স করে দিয়ে দেবেন। আমি তো রেকর্ড করেছি এটা।
12 দিনের last
Next.
this one. Eight. এক্ষুনি
দিদি ফাইলটা আলাদা রাখুন।
Lord, I am for the petition. Contempt application.
ফার্স্ট টাইম ওই ফাইলটা আলাদা রাখুন, ওটা ঢোকাবেন না, আবার ডিপার্টমেন্ট থেকে ব্যাক করবেন। আমি রেকর্ড করেছি। Please serve and come back. The applicant petitioners are directed to serve copy of the contempt application along with annexure thereto upon the alleged contemner and file affidavit of service on the adjourned date. Paragraph, let the matter appear under the same heading on 16th April.
16th April.
Next.
Item 10, my lord. I am for the PD. Item 10 and 11, my lord, both the same matter, my lord. Yes,
My lord, with regard to item number 10, a report has been affirmed, but it is not with me, my
my
lord.
lord,
Kindly,
that is
kindly fix
record,
it.
my lord. 11, my lord, they have already submitted a report, my lord. You will also consider it. Exception also.
Two matters. 11 report is with me.
Yes, my lord. Kindly first 11 is taken up for hearing, my lord. Same matter, my lord.
It is item number 11 report. Exception
10.
report is not with me. It will be
10 চলছে তো।
না 10 11 টা আগে দিন till একই ম্যাটার
Let me call one by one. ফাইল সাজানো নেই আজকে। So 10, I'll grant an adjournment for him to file a report.
No, my lord. Your lordship has decided 11. That will be covered by the 10 also, my lord. My lord, same order,
Come
same.
up with separate report in this. How can I do that?
Yes, ma'am. Then my lord,
Learned counsel for the state respondents seeks extension of time to submit the report in the form of affidavit as sought. Paragraph, let the matter appear under the same heading on 17th April.
17
Let me decide the next matter, or shall I take up both together?
both to,
Shall I decide the next matter now,
no,
or together, both together?
no, my lord. Your lordship decide the next matter.
Item 11.
Yes,
is the report, my lord.
my lord. I have filed the exception.
My lord, we have received the exception afternoon, yesterday afternoon. Some time is required to go through the exception. Because
Lord, I have nothing, my lord. I have said, my lord, they have, my lord, 2023 not settle the accounts, my lord, compensation. I am entitled to, my lord, the fair account.
2013 Act compensation.
Yes, my lord. My lord, in this connection, my lord, I submit, my lord, the my lord, judgment, my lord. Several judgments passed by your lordship and, my lord, the appeal court.
time is
Yes.
required, my lord.
Yes,
Just
ma'am.
go through the
I-
exception. I could
Also, my lord, the judgment also, my lord, they will take
Let him go
instruction.
through it.
Yes,
Yes,
go
yes.
through it.
Report in the form of affidavit submitted by the state respondents and exception thereto submitted by the petitioners are taken on record.
Also, my lord, judgment also compels.
Will be on record. Or you can give it on the next date.
Yes,
Please hand over a copy to.
yes,
learned
already,
counsel so that we can
hand
go
over, already hand over, my lord.
through. Paragraph, let the matter appear under the same heading on same date,
Same day.
17th.
stop, my lord, otherwise from a long
It
I
is
pending.
appearing at the
My lord, 12, I am for the petitioner, my lord.
My lord, item number 12, my lord, I am for the respondent number 6, my lord. My lord, I am praying for not to.
Private respondent.
Yes, my lord. I am praying for not today, my lord, because my lord, we have received the brief just 2 days back, and Vakalatnama is not filed. Kindly, my lord.
Where is your affidavit of service?
My lord.
Have you served the state?
My lord, served but track report, but not annexed, my lord.
GP's office state?
State, yes. State has been served. Yes, my lord.
The GP's office has been served?
Yes.
With the track reports with regard to the private respondents?
Only private respondent.
Yes, are you appearing?
Lordship, private respondent number 6.
There are 2 private respondents.
Two private respondents. That is
What
the
about
private.
7?
My lord, private respondent
6 is appearing, 7?
7, my lord, same Montu Jana and Subroto Jana, but 7, the father's name
Not
is
served?
not unknown. Served, same address, my lord. Kindly see the affidavit service. I served the all the private respondents.
Serving is not issuing and serving are separate things. You have issued, you have not served. Has it been served upon the respondent? No.
Yes, I have served the respondent. My lord, kindly see Subroto Jana and Montu Jana, 2 respond. 5 first.
6 you are appearing.
Yes, Lordship.
This is issuing, sir, not serving.
Issuing.
They are 2 different things. Where is the service? No track reports. Please serve and come back.
My lord, only respondent number 7.
Yes. Since service upon the 7th respondent is affidavit of service. Do you need this or
Yes, my lord, kindly the confirm the track report. Then I will confirm that is
affidavit of service not darkar nahi. Since service upon the 7th respondent is not complete, comma, let the matter stand over till 17th April.
17th April, my lord.
Great.
Page. At a page.
নামটা দিলাম একটা পেজ দিন তো দিয়ে লিখে দাও
My lord, I am appearing on behalf of the writ petitioner. My lord, this is the second round of litigation.
Have you served? Mr. Dey, your appeal? Yes.
My lord, this is the second round of litigation wherein I am seeking implementation of the order at page, my lord, 74 of the writ petition, my lord. And the relevant part is at 77.
74 is a writ petition.
Yes, my lord, this is the order. I am seeking implementation of order in this writ petition, my lord. My lord, there was a direction on the,
order.
My lord, the order is at 77, my lord. Relevant, it starts from 74. The relevant part is at 77, my lord. The grievance of the petitioner is directed against the proceeding pending before the Block Land and Land Reforms Officer, being the respondent number 5 hearing. It is submitted by the learned advocate appearing on behalf of the petitioner that notwithstanding an order passed in appeal number 115 of 2014 by the appellate authority under section 54 of the West Bengal Land Reforms Act 1955, the respondent number 5 has taken no steps to finally dispose of the subject proceeding pending before him. Mr. The advocate appearing on behalf of the state respondent submit that he has no objection if the direction is passed on the respondent number 5 to consider and dispose of the proceeding pending before him within 3 months from date. In view of the submissions made by the parties, I direct the respondent number 5 to dispose of the proceedings, which was remanded back in terms of the order dated 2nd December 2015, passed in appeal case number 115 of 2014, be disposed of within a period of 3 months.
So this has not been.
No, my lord, hearing notice.
Primarily, the difficulty is this court doesn't have jurisdiction to deal with this.
My lord, may I?
But then, since
My
there's an earlier order,
Order,
there'll
miss.
be only an order for compliance of this order, nothing more.
Yes.
The Land
Yes, ma'am.
Reforms Act, this court will not have jurisdiction.
Yes,
to
but
do
my lord, well, in my case is
But
that, my
since
lord,
there
I
is
am
an
seeking
order-
implementation order. If the order is also wrong, it is binding on the parties. And today, my lord,
Absolutely.
yes, my
It's
lord.
not really wrong, it's without jurisdiction. Anyway, I'll ask for implementation, that's it. I'll not go into anything further.
Yes, my lord, our time limit may be framed, my lord, and my lord, because my lord,
Mr. Dev, 1 month.
1 month. Yes.
Within 1 month. Heard learned counsels for the parties. Paragraph, the petitioner seeks implementation of an earlier order passed by a coordinate bench of this court on 23rd August 2021 in WPA number 24038 of 2019. Though the said order was directed to be complied with within 3 months from the date of order, comma, the concerned respondent, comma, being the
respondent number 5, the block land and land revenue officer.
respondent herein, has not cared to comply with the same till date. Paragraph, in view of the above, the writ petition is disposed of, directing the 5th respondent to comply with the order passed by this court in WPA number 24038 of 2019 on 23rd August 2021 within 4 weeks from the date of communication of this order, positively upon affording reasonable opportunity of hearing. Oh, that's already recorded, so let me not record it further. Positively stop them.
My lord, kindly
Session.
records it. My lord, I will indicate in the list of dates and hearing notice was given. My client went to attend the hearing, but no hearing took place. He had intimated it to the.
I propose not to go into further details because what is actually on
My lord,
case, I'm not supposed to deal with this matter. West Bengal Land Reforms Act, the writ court single bench cannot deal with. So let it be this much. It will suffice, I'm sure. They shall have disposed of आगे बोले छी. There shall have no rest costs since no affidavit or urgency for website.
Much obliged, your lordship.
Next.
ये चालू है तो ब्लॉक के बुक
14.
For the petitioner.
Yes.
This is my affidavit, sir. My lord,
Mr. De, your opinion?
yes, ma'am. This is regarding, admittedly, the petitioners are the members of a cooperative society in HIDCO land. And as per the audit report, my lord, this is regarding refund of the excess stamp duty and registration fee.
Refund of?
Excess stamp duty and registration fees paid in the registration of the conveyance deed. My lord, kindly come to page 29, annexure P4. That is the audit report.
Yes.
My lord, in the last paragraph, page 29. The last paragraph, members contribution, balance of members contribution account arrived at rupees this much, my lord, 9 crore something. And it was a bulk cooperative, my lord. So if we divide this by 32, so the total valuation for the flats comes at around 29 lakhs 21,971. So believing in this, my lord, we had gone for the registration of the deed, my lord. And we were of the view that the set forth value, which is of 29 lakhs 21,000, that will be taken into account, and accordingly the stamp duty and registration fees has to be paid. But surprisingly, my lord, I'll kindly come to page 33, page P5.
33?
Yes, my lord. And in that, my lord, set forth value is 2921 as per the audit report. But surprisingly, my lord, the value, the registrar had assessed it at 57 lakhs. And accordingly, we were directed to pay stamp duty at 2 lakhs 8 and registration value at 57,000, which is in total disregard of the notification. My lord, kindly come to page 84.7. In that it was mentioned the difference, page 84, 84, my lord.
84.
Yes, my lord. P7. As per the notification, my lord, Governor 1, 2, 3, 4th line from top, my lord. Governor is pleased to hereby to remit the stamp duty and registration fees chargeable under the above mentioned act, respectively, on the amount of difference, my lord. Difference, if any, between the cost of construction of the property of a cooperative housing society in a state to be determined on the basis of the audit report. My lord, the audit report is in page, which I just shown, my lord, in page 29. Yes. On the basis of the audit report of the cooperative housing society, including the additional cost incurred by the individual members towards interior works as suggested by the registering authority concerned,
So this
and
also has
the
been
present
remitted.
value. The
This also have been remitted, the difference.
My lord.
You are not supposed to pay the difference. That is your case.
Yes, my lord, the difference has not been accounted with.
Remitted. Yes.
So I have paid on the higher amount, my lord, excess of 1,25,000, my lord. So that amount we need. This calculation is, my lord, in page 20, my lord. Paragraph 20, my lord, in my writ petition.
Lord, you filed an application before the authority, my lord.
Yes, my representation has
considered by the authority, my lord.
My lord, it will take a long process, my lord.
Otherwise, it will take time, my lord. I must file affidavit and other things, my lord. So, we filed an application before the authority.
Representation.
That will be considered by the Inspector General of Registration, my lord. He is the authority.
Respondent number 2.
Respondent number 2, my lord. We will consider, and that will, my lord.
Yes, what do you suggest?
My lord, if my lord can adjudicate this thing, because it's a clear violation, my lord. They have not done it on the valuation was not done on the difference amount, my lord. So
where is your representation? You have stated the entire fact.
Yes, my lord. The representation is page, my lord, 85, annexure P8.
Everything is stated, my
Everything is stated, and in the last paragraph, in page 87, I have made the calculation and everything. Calculation is also there. In page 87, last paragraph.
I have seen all because that is it I told you.
Excess is 1,25,133. I have paid.
Let this be considered within a stipulated time frame, and you will be given an opportunity of hearing.
To the petitioners, there are 2 petitioners.
Yes, yes. Both the petitioners will be given an opportunity. You can place your entire facts before the authority, right?
Great.
Affidavit of service. Paragraph, heard learned counsels for the parties. It is contended on behalf of the petitioners that they are flat owners and members of a bulk residential cooperative housing society in the second page of your representation, you say that you are under a strong impression that the stamp duty would be calculated relying upon the cost of construction.
Cost of construction.
That is the fact.
Yes, ma'am.
The petitioners.
But as per the notification, it will be on the difference of the amount.
The petitioners.
Difference of the evaluation.
Were under a strong impression that the stamp duty would be calculated on the basis of the cost of construction reflected in the audit report.
Yes, my lord.
In the audit report of the society. And registration fee would be calculated at the rate of 1% on the cost of construction. Stop. The petitioners learned from the office of the ADSR Rajarhat that the market value of the respective flats were estimated to the tune of rupees 57,00,791. What is the set forth value?
Set forth is the, my lord, the one which we mentioned in the deed, my lord. This is as per
The set forth value was rupees 29,
in the cost of purchase, my lord, as per the
21,
audit report.
971. 29,21,971. ACT FORTH, একটা শব্দ। Paragraph. Learned counsel for the petitioner has taken this court to a notification issued by the Finance within bracket new bracket closed department, Government of West Bengal on May 12, 2022, which demonstrates that the governor is pleased to remit the stamp duty and registration fees chargeable under the relevant acts, on the amount of difference, if any, between the cost of construction of the property of a cooperative housing society in the state as capital, to be determined on the basis of the audit report of the society, including the additional cost incurred by the individual members towards internal works, as suggested by the registering authority concerned, and the present market value of the property as per assessment made by the registering authority for the purpose of execution of the deed by the society in favor of its members who purchased or otherwise acquired their plots of land themselves through the said society and not by any promoter. Stop. The petitioners seek, you have paid the amount already.
Yes, my
You are
lord.
seeking refund.
Refund, my lord. On protest, I have mentioned it in my paragraph.
The petitioners who have paid
Paragraph
the
13,
excess,
my lord. On
paragraph?
protest, I have paid.
Paragraph 10.
Paragraph 13, my lord. On my petition, my lord. Under protest, we have paid that amount. And in near future, your petitioner thought it to be prudent to get the deed of conveyance of the petitioner registered through the special officer under protest immediately and
The
thereafter
petitioners
approach the
have
respondent.
paid the excess stamp duty. It's the stamp duty.
Yes, ma'am. Stamp duty and registration fee.
Stamp duty and registration fee under protest. Claim refund of the same. Stop. The petitioners submitted a comprehensive representation before the concerned authority in this regard on 30th September 2022, which is yet to be considered. Stop. The petitioners pray for a direction upon the authority to consider the representation at the earliest. Paragraph, learned counsel for the respondents submits that who should consider?
Respondent number 2.
Yes.
Respondent number 2.
The second respondent be directed to consider the representation in accordance with law. Paragraph, in view of the above, the petition is disposed of directing.
My
the
lord,
second
as
respondent-
I have not any filed any objection or anything.
It will be recorded, yes.
Yes, my lord. As
Yes,
because,
of course. That's the usual line.
because there is some illegality of the statement made in the
Disposed of directing the second respondent to consider and dispose of the representation submitted by the petitioners
without the
dated such and such within 1 month.
Yes, ma'am.
Within 1 month from the date of communication of this order, upon affording reasonable of hearing to all concerned, including the petitioners, in accordance with law. Paragraph, the decision taken by the authority shall be communicated to the petitioners within a week thereof, disposed of with chatelaine, since prohibited with habit.
Alright, upon giving opportunity of hearing, upon giving
Next. Fifteen.
15, my lord, in this matter, my lord, I am appearing for the petitioner.
Yes. Oh, Mr. Roy is not there.
My lord, this
You're not real, you're
Jalpaiguri.
Yes, sir.
Jalpaiguri, be candid with your lordship. Jalpaiguri. My lord, what happened in this matter, my lord? In the year 1983, a notification was issued under section 3(1) of the Act 2 of 1948. My lord, can you turn to page 22?
Yes.
Page 22, my lord, your lordship will find this is a notification under subsection 1 of section 3 of the West Bengal Recreation Acquisition Act 1948. And the plots of the petition are also incorporated, that my lord will find page 23. Page 23, right hand, my lord, your lordship will find Mouja Jotkanu. Page 23, my lord, got it?
Yes.
99, plot number 99, 108, 109. My lord, got it?
Yes.
These are the plots which are the subject matter of recreation under the Act 2 of 1948. After that, nothing has been done. No ever declared, no payment was made, nothing. And now, my lord, it is lapsed. Now, my lord, under Pothosri, this portion has been declared to be for the purpose of making construction. A notification was issued that your lordship will find at page 29, 416.
Yes.
Serial number 416. This is the plot of land which is for the purpose of Pothosri under the Pothosri scheme. So my prayer is simple. If you want to utilize my land, you have to complete the acquisition process under the new act. Then, my lord, any three can be done over the same. I've categorically mentioned in paragraph, my lord, that they are started to make construction that your lordship will find at page 8, paragraph 15.
They are utilizing the entire land.
No, my lord, these three plots.
Yes, all these three plots.
Yes, this includes, this is a stretch of land, my lord, where three petitions are there, 15, 16, and 17. The persons who are owner interested in the portion of the land, they are before your lordship. The moot question is this. And paragraph 15, I have categorically mentioned that under the Pothosri scheme, this will be utilized.
Let us hear the state.
Yes, my lord, the state.
My first point is this, my lord. He has stated in the paragraph 2, the land has been acquired in the year 19.
Paragraph 19.
3 of the read petition.
3. Page 4. Land has not been acquired. The notice was
Notice was issued.
Yes.
Thereafter, my lord,
Yes.
possession and paragraph possession of the affected land was taken for construction of the road. I am putting my question why he has come after the 60 years. 65, 63, and today is 2020.
The road was not, you have to read it as a.
And then I have to take instruction, my lord. And my learned friend, my lord, submitted before the honorable court. The land has been utilizing now by proposed by the panchayat, Nimo Gram Panchayat. What he has annexed, I don't know, my lord. There is no pagination in my writ petition. Yes, yes, 29. I don't know what is this, my lord, what he has shown before your lordship. Serial number 415. What is this? I don't know, my lord. There is no relevance. Thereafter, he has made a representation before the authority on 17th July 2023.
But this
Last
document doesn't indicate anything.
Nothing. Nothing.
Only because it is a portion which is published.
Plot numbers, the plot
Under
number.
no, there is no plot number. That is why 416 I have mentioned categorically in my paragraph also.
It doesn't say anything. It doesn't indicate anything.
Nothing.
The purpose, the plot
That is a portion, my lord, that is a portion, my lord, which is within our plot number. Maintenance of CC road from 38 number railgate to Mazdara DVC canal. My lord, this is the portion in respect of which my plot is there. The state cannot deny that this document is not known to them.
I don't know.
It is a document which
I am denying. There is no relevance.
Let the state deny. Let the state deny that this plot does not include in,
next one page, there is no mention, nothing. What one it is, the land has been utilizing by the
come back with the report. Because the petitioner says it was not acquired, acquisition lab.
As your lordship desire.
Let the petitioner come back with the report.
Yes.
Affidavit of service. It is contended on behalf of the petitioners.
On maintainability point, my lord, I am raising my question, my lord. After lapse of so many years, he has come before this honorable court.
That notification under section 3 within bracket 1 of the West Bengal Land within bracket acquisition and acquisition bracket close Act 1948.
My lord, may I submit one thing? My learned friend, my lord, submitted the land is now utilizing by the Nimo Gram Panchayat for construction of the project. Let the Panchayat be make a party. Otherwise, my lord, constructing the road. I am not representing.
Whether my learned friend is probably not aware of this scheme. This is the scheme floated by the state government for the purpose of upgradation and construction. It is done by the agency, either by a panchayat or by the Jila Parishad, but the main nodal agency is the state of West Bengal, and that is through Public Works Department.
As your lordship.
Was published. On August 10, 1983, in respect of several plots, including that of the petitioners. Stop. So, notification under section 4(1) small a of the Act was subsequently issued. Comma. The acquisition was not proceeded with and ultimately lapsed. Stop. Possession of the plots was taken by the respondents. When did you learn about this Mothosri project? Paragraph?
Paragraph 14.
14.
14, my lord.
No date mentioned, madam. Only said that the subsequently the Department of Panchayat and Rural Development started project.
Yes, there is no date also. When did you come to know about this? Stop. The petitioners have learned that the plots in question Stop. The petitioners have learned that the plots in question
Page 29.
29.
Page 29.
are being utilized for construction of road under the Pothosri scheme by the Department of Panchayat and Rural Development. The petitioners pray for a direction upon the authority to initiate fresh acquisition proceedings in respect of the said plots and grant compensation to them in terms of the right to compensation 2030. Paragraph, learned counsel for the respondents seeks to submit a report in the form of affidavit in this regard. Paragraph, let the matter appear under the same heading on 18th April.
No, 15, 16, 17 are the same.
Same order?
My lord, 15, 16 and 18, not 17, my lord.
18. So,
Same order be passed?
same.
Which matter? 16? 18. I 16.
I am for the petition, my lord.
Same, similar.
No.
16?
Sir, 16 আপনি?
No.
16, 18 দুটোই আপনার served the copy, man. State has been served. 16, 18 দুটোতেই আপনি?
আমি 18
60 থেকে?
16 এ কেউ নেই
তাহলে 60 থেকে
16 হাওয়া হয়ে গেছে
চন্ডিদা আছে তো?
আমি 18 আছি গো আমি 18 আছি
শীত গ্রীষ্ম বর্ষা চন্ডিদাই ভরসা।
না এটা নয় আমার সঙ্গে তো ইয়ে নেই my lord in my
I don't know, but I have served same project, same thing.
আরে দাঁড়াও
Other portion of the plots.
My lord,
16, my lord. Mr. Shupanin Dhar, led by appear for the state, my lord.
Yes. So are you
সিমিলার অর্ডার ও ইয়ে চাচ্ছে ওর my lord অর্ডার দিয়েছে that order সমিতকে যা
Report, filing of the report.
Let it be adjourned because it's not there.
my lord, Mr. Dhar, my lord, is appearing, my lord.
Third is appeared, my
Appearing for the agenda of 16 for the state, my lord.
Yes, are you ready for the hearing today? Only
Dada acho,
mentioning
Dada
his
acho.
name will not be sufficient, isn't it?
Yes, my lord.
He has to be present. Only mention his name is not
And
sufficient.
definitely.
দাদা আছো তো?
My lead.
Yes, where is Mr. Dhar?
Engage in court number
দেখা না P6টা দেখা না
my lord.
P6টা দে না
Affidavit of service.
Sir, কোনটা? 18 টা, 18 টা?
Care of the
18
state
টা.
respondents, the matter be adjourned. Paragraph, let the matter appear under the same heading on the same date.
এই যে সংকট।
Same date.
As you wish.
Next.
my lord I filed the yes my lord
My lord,
দাঁড়া
this is in respect to item number 18. দিদি, এটা 18, 18
এটা 18 17 না
কতটা পড়েনি? এটা 18টা।
17 কল করছি
18 সেম ম্যাটার 18 টা দিয়ে দিন 17 রাখছি
দাও মাইলট কে দাও 18 টা দিয়ে দাও 18 চলছে 17 টা একটু বলো তুমি 17 আছে 1 মিনিট আমারটা হয়ে যায়
Yes.
My lord, in this matter, my lord, land has already 3 notice were for requisition and acquisition are there. After that, that was lapsed, my lord. Now, my lord, if your lordship will come, page 29, my lord. No, my lord. I have filed the report, my lord, that the report that land was 3, my lord, was issued for requisition. After that, 4(1)(a) for acquisition was there, complete. But as the money was not paid to the land user, that was lapsed. Automatically, my lord, those lands will be. Now, those lands is now, my lord, in the page 29. তো এলএ কেস নাম্বারগুলির পরিপ্রেক্ষিতে দ্যাট হ্যাজ মাল্লার বর্তমানে ভূমি অধিগ্রহণ আইন অনুযায়ী ক্ষতিপূরণ প্রদানের জন্য আবেদনপত্র জেলা শাসক উক্ত অভ্যস্ত ব্যস্ততার মধ্যে মাল্লার দে ফাইল্ড অ্যান অ্যাপ্লিকেশন বিফোর দ্য অথরিটি আমাদের এখানে দেখা যাচ্ছে এবং মানি was not paid to your client. Now 29 is there.
No, I am not on that. At least, my lord, the state come forward and say
that is a filed one application before the authority district magistrate. District will consider this application till such application.
But the Pothosri can be continue or not, my lord? That is a main question.
No,
the state will not make any construction before acquisition. I have no objection.
Pothosri should not a very essential thing, my lord, that without giving any money or anything else, that Pothosri will.
That is continuing, my lord. Otherwise, these parcels are not coming before your lordship for the purpose of the same.
That
notification issued, tender issued.
Yes, that is for that reason.
Once tender is issued, my lord knows now it is not in the hand of the government. It goes to the contractor itself.
তুমি কি চাও? What you want now?
আমি চাই
this application.
ল্যান্ডটা ছেড়ে দাও আমি বাড়ি চলে যাব।
হ্যাঁ? ল্যান্ড কি করে
ছেড়ে দাও বাড়ি।
না you without giving any without starting any proceeding on anything else, it should not be done. It is the principle of the.
That is my submission. That is my submission also.
Welfare state can't took money, took land from anybody to the people without any giving any proceeding.
That is why that is my submission. Exactly what is fallen from you. That is my submission.
My lord, that is the position of law, man. So, my lord,
the project cannot be implemented without acquisition.
Necessity of if they file any representation, my lord, that will be considered, and if until such disposal, no, there is no any construction will be made, my lord.
Grateful. My lord, I bow down to this.
Yes.
You have already.
I am bow down.
Yes, my lord.
17th July.
Yes, my lord. I have no objection. I have no objection.
With respect to my lord, item number 18, my lord, page 39.
We are in 18. Page 39.
39, yes, my lord.
As we, my lord, we have already requisition the land. After that, acquisition was there, but as money was not paid, now the Pothosri, in the way of Pothosri, we never want to grab the land of the land user.
That is why.
হ্যাঁ সেই তো মাইলটকে তাই তো বললাম নাম দিয়েছি তোমাকে আমাদের নামটা
my lord page 39 annexure P10 my lord that is my representation my lord sub my lord
একটু ভালো করে দিতে পারিস না লিখতে পারিস কাগজটা
ইয়ে হয়েছে না
কালো দেখ
আমারটাও কালো স্যার
যাই হোক
my lord, let this representation, my lord, be considered, my lord. My lord, taking into consideration the report filed by this court.
Yes, my lord, I have already filed the report,
my lord.
I'll record that.
My lord, one prayer can I made before your lordship? A copy of the report be also submitted to us, so we can represent ourselves.
It has been served. It has been served.
I have already handed
over.
Sorry.
No. So I'm.
Submitted on behalf of the state respondents is taken on record. Paragraph, third learned counsels for the parties. Paragraph, it is not in dispute that notification under section 3 within bracket 1 of the West Bengal Land Requisition and Acquisition bracket closed Act 1948 was issued sometime in the year 1963, and possession of the land was taken in 1968. These are admitted facts.
My lord.
Stop. Thereafter,
Yes. That's why I admitted.
Yes.
thereafter, comma, notification under section 4 within bracket 1 small a of the Act was published. Stop.
May your lordship leave.
Award
Grateful to us.
could not be declared due to non-placement of fund by the requiring body and the acquisition proceeding lapsed. Paragraph, learned counsel for the petitioners submits that the respondents are trying to utilize the plots in question for the Rasta Sri scheme.
Pathosri.
You've stated Rasta Sri here.
My lord, paragraph number.
Sri scheme at inverted comma Raghavan.
My lord, 14, my lord. Paragraph number
The
14.
representation says Rasta Sri. Page 40. Without acquiring the same or compensating the petitioners in lieu thereof. Stop. The petitioners submitted a comprehensive representation before the concerned authority on 17 July 2023, which is yet to be considered. Stop. The petitioners pray for a direction upon the authority to consider the representation at the earliest. Paragraph. Learned counsel for the respondents submits that Special Land Acquisition Officer. DM. The second respondent be directed to consider the representation in accordance with law. Paragraph, in view of the above, the petition is disposed of, directing the second respondent to consider and dispose of the representation submitted by the petitioners within 1 month. Within 1 month from the date of communication of this order, upon affording reasonable opportunity of hearing to all concerned, including the petitioners, comma, in accordance with law. Paragraph, the decision taken by the authority shall be communicated to the petitioners within a week thereof. Paragraph, pending disposal of the representation, comma, the respondents are restrained from raising any construction or encroaching upon any portion of the plots in question.
Grateful.
Raising any construction in or encroaching upon. It is disposed of. Next.
17, my lord, was
17.
7.
17, you are appearing.
I'm appearing.
For the statement.
My lord, Miss Monica Rai, my lord, is to be there, my lord, for the NH. My lord, she has received a copy of the brief, my lord.
Have you served?
Served upon her, my lord, received. My lord, but affidavit of service, my lord, has to be prepared, my lord.
Not ready. Since she is not appearing, please come back with your affidavit of service.
Yes.
We should also take a instruction from my client, because their allegation is that not en bloc arbitration, individual notice has not been given. We shall also check the records.
My lord, my only consideration is, my lord, my only point is, my lord, that my application, my lord, annexed at page number 22, my lord. Under 3G5, my lord, that is to be considered, my lord. I've made the application, my lord. That is yet, my lord, in 2019 itself. That is pending till today.
Not today.
Not today.
Short matter can be disposed of.
After a week, because I'll get the instruction then in the meantime, because we shall try to see whether he has participated or any arbitration has taken place.
Very well, let him come back.
Very well, very well. Much obliged.
Learned Counsel for the state respondents seeks to take instructions in this matter. Paragraph affidavit of service is not ready. Paragraph, let the matter appear under the same heading on 10th April.
10th April.
Much obliged.
Next.
Well, I am appearing for the petitioner, Malad, 19 to 27, accepting 25. But last occasion, your Lordship directed the state correspondent to bring the report of this case.
In this matter, my lord,
Last
I'll be appearing on behalf of Midnapur municipality in all matters.
Item number 20, because I beg to appear in the state list.
And let's deal with 19 first.
19.
There are similar matters.
Malad,
I do not know.
Almost similar, almost similar.
Mr. Dey.
report.
With me, my lord, not before ADB, not there, my lord. My lord, if I find this, my lord, brief history of this case, my lord.
Last occasion, your Lordship directed state respondent seeks to submit a report in this regard annexing relevant documents.
Actually, the report দিয়েছে রিপোর্টটা দিয়েছে দরকার নেই
কিসের দরকার?
এফিডেভিট কি
এক্সেপশন দিতে হবে রিপোর্ট।
রোজগার হবে না
রোজগার তো
আপনি এক্সেপশন দিন না এক্সেপশন দিন দিন এক্সেপশন
একদিনে মামলা চললে হবে।
রোজগার তোমার
আগে মামলা হয়েছে
আরো হবে।
আগের দিন হয়েছে তো মামলাটা
আমরা 10 দিন চলবে।
চলুক আমার অপশনে ফিস বাড়বে দাদার বাড়লে ভাইয়েরও হবে
Yes, have you seen the report?
No, I have not seen the report. Question is, Malad, I have to see the report. Then I have to take the exception of this report because the first time it has been considered by the respondent authority that is rejecting the prayer of the petitioner. Then thereafter came before this court and Lordship directed to bring the report. Then, my lord, how it is accusation has been made under what act, my lord, I have to see this.
My lord, may I submit, my lord, on behalf of Midnapur municipality? Last occasion, I had taken the point of non-maintainability of the writ petition, my lord. My lord, fact is that, my lord, previously land was the state government. This government was the owner of the land and it was recorded in Khotian 1. And in the year 2017, interdepartmental transfer was made and we got the land from state government and we have erected our project water treatment plan over there. And this petitioner before Lordship, my lord, she has purchased the land in the year 2020 and land was given to us in the year 2017. Number one, that is the right to sue. She has no right to sue. Second thing, my lord, this entire allegation made by the writ petitioner in this writ petition that we have acquired the land. That is not the correct, my lord. Because, my lord, land itself was vested, interdepartmental transfer was made. My lord, we got the land and we have started our project. We are not neither the acquiring authority nor the requiring authority. Land was, if it was acquired by the state government and it was vested and it was given to us. That means question of giving compensation does not arise. Even, my lord, if your lordship comes to the impugn order at page 87.
Page 77.
Page 87, my lord. May I read out, my lord?
But page 77 recorded owner is the petitioner.
My lord, petitioner alleged the bottom of the page 87.
That the municipality has acquired the property without following the relevant provisional law as laid down by the West Bengal Municipal Act 1993, and the authority failed to pay any compensation in terms of the land acquisition and revision and resettlement act 2013. Next page, my lord, 88. And no notice either under the provisions of the Municipal Act nor any intimation thereof was giving to her about the intention of the acquisition of said land. This was the allegation. Now, my lord, the block land and energy reforms officer Midapur Sador present for hearing and stated that the mentioned plot was vested to the state. Some pattas was issued in the year 1971-72. Rest of the plot was vested and recorded in collector's Khutian. Amongst that land, the alleged petitioner's land is from that portion. Rest of the plot was vested and recorded in the collector's Khutian. As per the proposal sent from Midapur municipality, interdepartmental transfer has taken place, maintaining all the formalities.
Documents of vesting.
That is my lord, only
Khutian
question.
number 1. Where are those documents?
That the state government is having the records, my lord.
Last occasion, your loss is directed to
Annex any document.
annex the documents, bring the relevant documents. What is the notification? How it is vested? Municipality is saying so many submission, making the submission on behalf of the
The
municipality.
vesting documents need to come before the court. The transfer documents need to come before the court. How it was transferred to you?
The transfer document is there.
Kindly see the page 77.
I've seen record of
Himalaya.
rights. If it is after the vesting, doesn't really matter.
My lord, I have all my lord equal but not annex all the my lord. My lord,
Please come back with a report in the form of an affidavit because the merit of the writ petition depends on that.
My lord.
the petition is not maintainable as because the vested.
Without record, my lord, your lordship will give the order.
Yes, my lord. Only for that is my lord.
The vesting documents, the transfer documents.
Yes, ma'am.
When
I am
it was vested-
saying before lordship, that's document.
When it was vested, when it was transferred.
My lord, but that was not annexed to that then. All the documents is there.
Although I am appearing in respect to item number 20,
Yes.
the bunch of documents my learned senior friend appearing with the state respondent submitted, your lordship would find there are inter-department transfer of government land.
Yes, but the documents,
That was.
That was there, my lord, I believe. And writ of possession is also there, my lord. Municipalities took the
Who has
project.
given the possession?
He is
State giving the possession to the municipality.
Yes.
Without any notification. That is the case.
Well, that has not been challenged. Interdepartmental notification, what my language is talking about. The writ of possession is also there. You also have seen it.
Departmental transfer was made in 2018.
Yes, they are after your lordship kindly skip over and 3 or 4 pages after the writ of possession is there.
No, that is not a dispute.
Yes, but my lord, he has purchased the patta land. In the statutory
No,
provision,
how,
is
my
this
lord?
cannot.
That cannot be challenged.
Violation of statute, my lord. My lord, your lordship kindly see the first, my lord, the statute.
No, it is vested without notification.
Notification is there. Gazette
So
is
what
there.
is the submission?
Gazette is there.
What is
That is relevant documents. I have not seen your lordship seen. Whether it has been seen by your lordship, I don't know. That's why your lordship asking
kindly see
record.
the provision of statute. Kindly see.
But without going through the
This is
records,
first-
my lord,
First,
Please allow him to submit, sir. You are
My lord.
making
My lord.
simultaneous submissions.
he is appearing item number 20. my
similar
lord.
matter, my lord.
Same issue.
Same issue. Issue is
Same
the
issue. Yes, I mean 20. But if your lordship kindly considers, my lord, the provision of statute, my lord. As your
Yes,
lordship,
yes.
my lord, Act of 1975, your lordship has seen. Kindly comes, my lord, 1A, next page. As your lordship got it? Last
Yes,
4,
yes.
my lord, what's starting no person with whom land or has been settled under subsection
L shall be entitled to transfer such land except by you have a simple mortgage or a mortgage by deposit of title deed in favor of a scheduled bank or a cooperative society or a corporation owned or controlled by the central or state government or both, and for the purpose of obtaining loan for the development of land or for the improvement of agricultural production or for the consideration of dwelling house. This is the provisional statute, and my lord, if your lordship kindly take.
So one thing, the petitioner has not been served with a copy of these documents. So the petitioner needs to go through these documents.
Yes.
The vesting documents, the transfer documents, so that he is also aware of what has happened.
And he can also file a exception.
Now I am not aware of
That would be
this.
better. The next
That is
occasion,
happening.
entire matter will be.
Please serve a copy to me.
Yes, my lord, I
We
must.
take this back.
Yes, my lord, take back.
এটা ফেরত দিয়ে দিন ওনার।
দিদি একটু দেন না পুরো।
And it should be on record, my lord,
Absolutely.
by the form of.
The learned counsel for the state respondents seeks extension of time to submit the report as sought. Report should was as sought. Paragraph 17th April, all the matters.
17th April.
If you can please serve an advance copy.
Separate order, so that.
কি বলছে 17th
Separate order.
17th April.
17th April.
নাম স্লিপে আল্লাহকে লিখে দেবে।
Separate orders. I'll call one by one, Mr. Doctor. Yes. 17th April.
17th May.
April.
17th April.
Item 20.
My lord,
The
similar
same,
matter,
same.
I have advanced.
Same order be passed.
Same order.
একটা করে দিন এখানে রিপোর্টের কথা বলা হচ্ছে।
সব সিমিলার অর্ডার।
তত দেওয়া আছে।
আমাদের
Same order.
My lord.
Please come back with your reports on the next date. With the documents.
21 same.
21 state. State.
21 কে তোরা
Same.
21
দিতে বল।
নাম বলে দাও কিছু বলার আছে।
Thor is appearing.
My lord.
বল নাম
স্লিপ লিখে দিয়ে দাও কিছু। My lord.
Your report.
My lord, I am not back with the instruction. My lord.
Same order.
Same order.
নামটা দিন।
Please be ready with your report on the next date. 22.
I am appealing for the state, my lord, same matter.
I shall give you same order. I shall give you. That order has not been served upon us.
But same order has been. You have challenged an order which was not served upon you.
No.
How did you challenge, sir?
But is the similar matter, my lord, I have moved the, before this court and directed to consider that matter has not been considered. So, but I have, in the paragraph, I have made this awareness.
It has not been considered as yet.
Considered, but not served. Similar order passed in all this matter, not served us. Not served us. So that I have not annexed.
So your repetition is premature.
Repetition, I have
Premature.
avert this in the writ.
How can you avert this without the order itself?
But in the supplementary, I shall file.
Please file on the next date. Otherwise, it will be premature.
The supplementary, I shall.
Mr. Bandyopadhyay, same order. Come back with your report, please, on the next day. Same order.
In the meantime, I have a supplementary evidence, I shall file. Give me liberty.
I have got this.
Same order.
Same order.
Same.
Reportটা আছে তো problem? Okay. Same order.
একটা গোসা মামলা কপিটা খাই
24.
Same.
I am for the state.
Same order.
এটা খাই এক গোসা
25 কেউ নেই 25 আমি আছি দাঁড়িয়ে 25 কেউ নেই
25 অন্য লোকের
25 not our 26, 27, same.
25.
25 not our matter.
এই তো 25 এসছে নাকি 25 হ্যাঁ এই
Yes. You are the petitioner.
বলো 25 তোমার বলো
Why not? আমি petitioner. On prayer of the petitioner, the matter is adjourned. Paragraph, let the matter appear under the same heading on 18th April. 56.
26, same as 19.
Same order.
26.
Same order.
Same as 19.
27.
Same as 19.
State.
State क्या है?
State.
सुनी ना?
Mr. Day is for the state. Same order, Mr. Day.
27.
27 दे दी?
26 तो आज आपने
अब
आपने
28.
My lord.
27 का दिन
Our matter is
बस হয়ে গেছে
On prayer of the petitioner, the matter is adjourned. Adjourned to 20.
my lord.
Paragraph on, let the matter appear under the same heading on 18th April.
Well, I appear for the petitioner, my lord.
My lord, I'm on behalf of the Atish Kumar Vishwas. So
You're on
praying
behalf of?
Atish Kumar Vishwas.
Yes.
Praying for a short passover, my lord. He's engaged.
It's not possible in this.
My lord, 4 times they are taking time.
We are ready with the reply. Just
Make your submission. No time will be granted. Make your submission.
Lord, the order passed by your lordship,
For the respondents, Mr. Bhatt.
Lord Soumitra, ma'am.
I am for the statement.
My lord, kindly, your lordship kindly pass, go to the order passed by your lordship.
Application, who is appearing?
Application, my lord, my learned friend is appearing.
Intervention application.
Yes, intervener. My lord, thereafter, they will not, they ask for affidavit. 4 times they are there, my lord, taking time, but no affidavit, till date, no affidavit.
we are, my lord, we are ready with the reply just because of.
Where is your reply? Affidavit reply?
Yeah.
No reply, my lord, affidavit.
Yes, my lord.
It's her application.
Yes, yes.
So she has to file a reply
Sorry, my lord, they are reply.
against the opposition.
Yes. My lord, your lordship passed the order on February 9. They took the time. They are, before that, my lord, 3 times. December 5. They are taking time. My lord, what I am praying on before your lordship, the order passed by your lordship disposing the application on 8 February 2023. My lord, directing the DLRO. My lord, kindly see the order. Directing the DLRO, the second paragraph, in view of the above, this court is inclined to hold that no fruitful purpose will be served for keeping by the writ petition pending. The writ petition is accordingly disposed
Has this
directly.
been complied with? This has been complied with?
No, my lord, they have challenged this order before the appeal court. Appeal court directed to hear them and to pass order. What I am praying for, my lord, if they have a grievance, my lord, your lordship directing the DLRO,
Where is the appeal court's order?
the appeal court order, my lord, in the applications, my lord. That is in
Where is the appeal court's order?
yours, my lord. The application, their application. In their application, my lord. Can number 1.
Yes.
Page 11.
So let the addition of party application be allowed.
My
The
lord,
appeal
let them allow, my lord. What I am praying for,
filed an opposition to this.
my lord, what I am praying for, my lord, your lordship directed the DLRO to, my lord, decide the matter, to hand over the.
You are on merits of the writ petition. Let us decide the addition of party application first.
Additional application, my lord, all,
Appeal court has given liberty to them
yes,
to be added as party. So let
yes.
this application be allowed without wasting further time.
I have no objection, my lord.
But you have filed an affidavit to this.
Affidavit on the basis that record. I brought out the record. Kindly see my affidavit.
The record is in respect of merits of the application, merits of the writ petition, isn't it?
No, my lord. They are claiming that they are in, my lord, possession by taking lease.
They have to prove that in the writ petition. So let them be added in terms of the order of the appellate forum. The division bench has given them liberty to come before
Yes.
this court. So without wasting further time, we are still on the addition of party application and not the main writ petition. If the addition of party application is allowed, we can go shift to the main writ petition, isn't
Yes,
it?
yes, my lord.
So let that be disposed of on merits.
My lord, that
So
was,
today, since she is not ready,
we used the, my lord, I have used the affidavit on the ground that they have no, my lord, document. The document we have not produced before, annexed before your lordship, that is the document by the, my lord, land department or fishery department, the document. And they are saying that no lease is, my lord, continuing. That is the document.
so let there be an adjournment, let them come back.
My lord, what I am on, my lord, your lordship kindly fix a date. And my lord, it
Let
may be,
prayer as a last chance. Next,
Lord-
be heard even in your absence.
my lord, let the application be allowed. Let the writ petition be fixed a date, my lord. My lord, we are, my lord, we are waiting for, we are not taking possession. Though the order was passed to your lord.
Suggested that let this be allowed. Why waste time on this application? Let the writ petition be taken up.
Yes.
Yes. So on your consent,
The, my lord, writ petition,
not the writ petition, the application for addition of party.
your lordship has
Yes.
allowed.
Yes. Can one of
Kindly, my lord, only prayer is fixed a date, my lord.
I will, yes. Since this hurdle is crossed,
Yes.
I'll fix a date for the writ petition. Can I order? The applicants seek to be added as party respondents in the writ petition in terms of such liberty granted in their favor by an honorable division bench of this court by an order passed in MAT 419 of 2023 on 20th April 2023. Stop. The petitioners and the respondents have no objection if the application is allowed. Paragraph, in view of the above, comma, the application being Can 1 of 2023 is allowed. Paragraph, the applicants who are the applicants here?
They are claiming that they are the leaseholder.
The names.
We are the owner, my lord.
No, I'm looking for their names.
Rahmatpur Anchal Fishery Men's Cooperative Society is the applicant. And Representative Wanil বিশ্বাস Secretary.
Rahmatpur Anchal. Rahmatpur Anchal Fisheries means, that is their application. Can 1, my lord.
Proposed added respondents are Rahmatpur Anchal Fisher
Yes.
Society and Anil বিশ্বাস. They,
Yes.
these two. The
Anil
applicant
বিশ্বাস,
included as
secretary of the society.
respondent numbers 11 and 12 in the writ petition. The cause title of the writ petition be amended accordingly. Please do the necessary amendments here and now. You have to add these names to the writ petition. Can such and such is disposed of. WPA te order korun eba. In re WPA korun. Let the matter appear under the heading Group 1 motion on 19th April.
19th
April.
But if your lordship convenient, but earlier, my lord, if it is possible.
This month there is no date. Come back on 19th. I'll deal with it.
19th April, as your lordship.
Next.
My lord, I am for the petition. I am for the petitioner. Shuddha acho?
State.
My lord, in this matter, my lord, the case in a nutshell, petitioner pursuant to the call of the authority is, my lord, estate manager Kollani, my lord, deposited salami by check for allotment of land. My lord, if my lord kindly turn page number 23. Page number 23. This is, my lord, check of 1967. Petitioner has
23.
Page number 23.
There are two. Yes.
My lord, it is a check, my lord, of 1967. Petitioner have deposited, my lord, salami money for allotment of land. Thereafter, my lord, if, my lord, during this time, my lord, 1967, during this time, my lord, while the petitioner, my lord, traveling, unfortunately, my lord, all the original documents has lost. If, my lord, kindly turn to, my lord, 27 page. Kindly, my lord. That is, my lord, the GD. All the documents which are actually public record has been lost from my custody. My lord, next annexures is the RTI, the representation gradually next accordingly. But I have asked the authority kindly supply me the documents of the original lease agreement or others documents relating to the land. The authority, as usual, not supplied. They have not replied. Very well. Now, my lord, when the authority, my lord, has not taken any action, my lord, I have approached this honorable court. My lord, if my lord kindly come to annexure page 38, when the land has not been handed over, even after depositing of the, my lord, salami money, and the documents also not given as per my RTI, petitioner approached before this honorable court. And before this honorable court, my lord, at the second stanza I am reading, having considered the submission made on behalf of the parties, my lord, may I read, my lord?
Yes.
Material on record, I dispose of the writ petition with the direction upon the respondent number 1, that is, my lord, estate manager, to consider and dispose of the application filed by the petitioner dated such and such within a period of 2 months from the date of receipt of this order, after affording opportunity of hearing. This is very important. After affording opportunity of hearing to all the affected parties, including the petitioner, in accordance with law. This is also very important. Now, my lord, before I invite my lord straightway to the, my lord, impugned order, I want to rely, my lord, 2 paragraphs of my writ petition. 2 paragraphs. My lord, kindly come. Paragraph number 2. Petitioner have stated, my lord, on oath before this court. I am reading paragraph number 2. That the petitioner states that he applied to the respondent number 1, that is estate manager, for allotment stroke lease of plot number such and such, block such and such, sub block such and such at Kollani town, district Nodia, which was leased out. I have specifically stated which was leased out and allotted to him by, my lord, kindly underline this portion, by allotment number such and such, 1967. And according to the petitioner deposited deposited salami or premium that I showed, my lord, check of the at the office of the respondent authority, white check number such and such 1967 for the said plot such and such, hereinafter referred to. Now, my lord, kindly come to, my lord, paragraph number 3. That is also very important, which I have stated on oath.
This agreement was executed.
Yes, my lord, that is my point. My lord, that the petition, I'm reading paragraph number 3, my lord, that the petitioner states that although the lease agreement was executed between the respondent authority and the petitioner on 21st March 1967. That is very important. That's why, my lord, I read the document paragraph about the said lease till the possession has not been handed over. My lord, pursuant to my lord's order, this honorable court's order, my lord, hearing was taken. If my lord, before straightway, my lord goes to the impugned order, if my lord kindly come to page number 40, that is my written statement, written submission, which I have, my lord, submitted at the time of hearing before the authority. My lord, if my lord kindly see paragraph number 2 and paragraph number 3, the same thing I have stated. The lease agreement executed by such and such number and executed on such and such date. Now, my lord, kindly come to the impugned order. My lord, page 69. Kindly see the arbitrariness, my lord, of the authority. Page 69. My lord, kindly do not, if my lord asks me what is the date of the order, I cannot say. Because, my lord, it is a cryptic order. I do not know whether the order has been created or manufactured after the hearing concluded or not. Because it is undated order. Kindly see, my lord. I am reading, my lord. Whereas it appears that the writ petitioner filed an application before the estate manager Kollani on such and such date and getting no relief from the estate manager Kollani, the writ petitioner, that is Tapush Kumar Bakshi, me, being filed a writ petition, that is, my lord, that writ petition before the honorable court. Now, my lord, they set out the order, my lord's order. Now, my lord, come to the next page. So it is, my lord, undated order. Next page, my lord, page 70. Next paragraph. Seen the petition dated such and such, in which the writ petitioner has stated that the plot number such and such, block such and such, sub block such and such was allotted to him by memo number such and such. That is that memo which I just, my lord, showed at paragraph number 2, and I have already stated in my writ petition. So they have, my lord, recorded this submission.
Your submission.
Yes, they have recorded my submission, but that has not been considered. That is my point. Now, my lord, kindly come next order, my lord. First order is undated. Next order, my lord, order number 2, dated 27th October 2021. My lord, this line is very important. Case record is put up today. The writ petitioner and his learned advocate appears and files hajira. My lord, kindly underline this portion, because, my lord, I have been called for in the hearing. I appeared with the learned advocate. Next, my lord, next page, kindly come, my lord, page 71. The learned advocate of the writ petitioner submit a prayer for time. Time prayer is allowed. Next day is such and such. Next order, my lord, order number 3, dated 3rd November 2021. CR is put up today. Again, I have been called for in the hearing, so it is recorded that the learned advocate on behalf of the writ petitioner appears and files hajira. I have been called, my lord. The learned advocate files written statement, which is in the part of the proceedings. DA, please place the case record for final hearing. Now, kindly come, my lord, next order. Order number 4, 27 December 2021. Case record is put up today. The writ petitioner was appeared with his learned advocate and files hajira. So I have been called, my lord, and I have duly appeared. Now, my lord, next, seen the written statement, which I have submitted, page 40. But I cannot show, my lord, there is reflection that they have seen and thereafter they have considered my written submission. I cannot show, my lord, because this is not written in the order, my lord, impugned order. Next, my lord, 72 page, which have been submitted by the writ petitioner, which is the part of the proceedings. In the instant case, the writ petitioner claims deposition of salami at the office of the estate manager Kollani by the check number such and such. The said receipt copy reflects payment of ₹914 on searching office record, that is lease registered. It appears that writ petitioner then deposited 10% of total salami, which was mandatorily to deposit at the time of submission of application application for obtaining leasehold right of plot number, that is the earnest money.
No,
So they are.
has been passed as yet.
Yes, my lord.
Final order has not been.
No,
passed
I'm
as
showing, my lord. I'm coming gradually, my lord. Final order has been passed, but it is. I'm showing, my lord. This is very important. That's why, my lord, I'm reading. So they are relying, my lord, upon their document. But I have on RTI an application sought for information. Kindly supply me the document. I have lost, unfortunately. They have not supplied.
Your document, the copy of check.
Yes, yes.
It was 9 something.
Yes, yes, yes. I have deposited, that is my case. I have deposited salami, and I also stated, my lord, my lease agreement has been executed.
You have deposited part of the salami, not the entire salami.
Very well, my lord. Very well. Very well. Very well. Now, my lord, I am reading, my lord, continuing, my lord. Submission from obtaining leasehold right, plot number such and such. It also appears from the lease register that amount of earnest money such and such. Since the payment, no further payment history is reflected at the lease register. Therefore, it can be concluded beyond doubt that only earnest money regarding the allotment of plot number such and such of Kolani Township is paid by the mentioned check number. Nothing more than earnest money is paid. Very well. They have, my lord, concluded their conclusion, my lord, based upon their register, my lord. Next is very important. So it can be concluded that as per clause 3 of the lease agreement, at least, my lord, kindly pause. If my lord asks me question, they are. No, I'm coming, my lord. I'm coming, my lord.
Mentioned matters are taken up from 12:30. So
But kindly give me 5 minutes, my lord. 5 minutes. 5 minutes. I have concluded. Just concluded, my lord. 5 minutes, my lord. It can be concluded that as per clause number 3 of the lease agreement, at least, my lord, I cannot say which lease agreement they are mentioning. Kindly see, it is a cryptic. Because here, my lord, lease agreement, if applicable, the lease agreement of 1967 is applicable, not any subsequent lease agreement. But they are vague in their order that which lease agreement they are mentioning for. Lease 1/3 of the premium of salami has not been paid within the stipulated time of frame of 2 months from the date of acceptance of the offer. Even the said amount along with stipulated amount in the interest mentioned in the clause 3. Again, they have not mentioned which lease agreement. So it is a cryptic. The prior for leasehold right had not been paid within the statutory period of 6 months from the date of acceptance of the offer. So, by virtue of the operation of clause 3 and clause 2 of the lease agreement, no lease agreement mentioned. Which lease agreement? The amount of money deposited, earnest money, was forfeited. Very well. Therefore, no longer there has been any relationship between the allotee, that is Tapan Kumar Bagchi, me, the governor of the West Bengal, exists as prior or payee. Now, my lord, kindly the last page, my next page, my lord. Now it's very important. However, it is found that a field inquiry was done previously and no trace of building was found. My lord, which field inquiry they are mentioning for? Who has, my lord, conducted this field inquiry? Whether I have been, my lord, summoned, I have been given notice before this field inquiry, my lord? Whose land has been inquired, my lord? I do not know. This suspicious, my lord, field inquiry report has not made part of this order. Kindly consider. They are mentioning for a inquiry report, suspicious inquiry report. I was not present at the time of such inquiry, my lord. Whose land has been inquired? So, a current field inquiry is required for taking the land in custody of the EM, estate manager. DA, please hand over the prior of the. So, a suspicious lease inquiry report. Now is very important, my lord. 7th January 2022. CR is put up today. My lord, there is no mention that I have appeared in that hearing.
I am afraid you have to continue on the next day. It will not be over in 5 minutes.
Next question is very important, my lord.
That's why, on the next day. Third learned counsel for the petitioner. Paragraph, let the matter appear under the same heading.
Kindly make it, my lord, part heard.
On part heard, not even heard properly. 11th April.
Well, 11th April. My lord,
we have only 1 more week in this month.
From tomorrow 31.
Yes?
From tomorrow 31 onwards. Yes.
Can it be in this month, my lord? Kindly, my lord.
Only the diary matters will be added.
My lord, can it be in this month, my lord? In this month, my lord, March.
Please show me when this month it can be done. We only have the next week in this month.
I'm suffering from my 2022, my lord.
In this matter, I am for the petition and also I have received the report in the form of affidavit. I want to use a exception to the report, so give me 2 weeks time so that I can make an affirmation.
May I file the report,
Yes,
my lord?
already.
Did you report this?
Little mistake.
The extension chain.
Instead of Purbo Bardhaman, it has been written as Purbo Mendipur. That has to be corrected. Not
It's Bardhaman.
yes, it's a matter of Purbo Bardhaman.
Let him come back with the exception. Inadvertent error has crept into the order passed on February 8, 2024. Paragraph in the second paragraph of the order, comma, the additional district magistrate and district land and land reforms officer, comma, Purbo Medinipur be read as the additional district magistrate and district land and land reforms officer, comma, Purbo Bardhaman. Paragraph, the department is directed to incorporate necessary correction accordingly. Paragraph, this order be treated as part of the order passed on February 8, 2024. Paragraph, report in the form of affidavit submitted on behalf of the fifth respondent is taken on record. Paragraph, learned counsel for the petitioner seeks to use an exception to the report. Paragraph, let the matter appear under the same heading on 11th April. Let the matter appear at आगे একটা line করুন. Learned counsel for the your respondent number
6.
6
6.
for the sixth respondent seeks extension of time to submit the report in the form of affidavit as sought. তারপরে let the matter appear.
Good.
Petitioner,
I am happy. We are awaiting for the petitioner, my lord.
have you served a copy?
Yes.
Have you received copies of both the reports? Yes.
Huh? There is no any second report, my lord. Only one report, my lord.
State's report?
No, my lord.
এখন দিচ্ছেন তাহলে ও একটা এখনই পেলাম এটা তো না দেখে তো
Do you want to go through this and come back, or are you ready for the hearing today?
No, my lord. Here and now I have got the second report.
Do you want to use exceptions to the reports?
Yes, my lord.
Yes.
I have to give reply.
Reports in the form of affidavit submitted on behalf of the state respondents and the KMDA are taken on record. Paragraph, learned counsel for the petitioner seeks to use exceptions to the reports. Paragraph, let the matter appear under the same heading on 16th April.
My lord, I beg to appear on behalf of the petitioner. My lord, this petition relates to, my lord, non-payment of compensation. Now, my lord, our lands were taken. We are not opposing that because it's the public facilities.
You are only
for
asking for
widening.
compensation.
Yes, lordship, kindly have a look. Then, my lord, I made, my lord, the RTI. My lord, kindly have a look, my lord, the reply to the RTI at page 56.
56.
Yes. Reply to your RTI petition dated so and so, addressed to the special land and land acquisition character. LA case bearing number such and such related to such and such is not really available and searching is going on. Information will be provided as soon as it is found. Now, my lord, then, my lord, I made a notice demanding justice. After filing of this writ petition, my lord, I have received this. My lord, kindly have a look. Only ये একটা কপি দিয়েছে কি বলেছে ওটাকে my lord, action taken report was short for
So they have taken steps pursuant to your application.
yes now my lord, action taken report till date nothing is my lord on record. But my lord, it is on the RTI application, the reply I have placed, my lord, page 56.
Where
Now,
is the representation?
my lord, this is at page 63, the notice demanding justice. Notice demanding justice.
Mr. Bandyopadhyay, since you have already taken steps,
I don't know, I haven't
এই ওটা একটু দিন
please give him a copy. Only one
তোমার
copy.
বললাম যে দুটো তিনটে কপি করে রাখতে my lord, kindly I shall hand over দু লাইনের চিঠি কথা বললে কথা শুনবো কোর্টের কাছে এম্বারাসিং রেলের লোক এসে তারপর ওই যে
Since steps have been taken, let it be considered within a stipulated time frame. Yes?
after opportunity and my lord,
Absolutely.
my lord, announcing and my lord, demolition of has taken place. My lord, that cannot be, my lord. I am praying only that interim for widening the road. My lord, that interim order, my lord, till such, my lord, is.
That has nothing to do with compensation.
No, that's true. But my lord, LA case is still pending. Otherwise, my lord, if it is ultimately, my lord, it is
Still get compensation.
compensation I shall get.
Order is
But by
there.
this time, my lord, kindly appreciate this position, my lord. If my lord, he has been thrown out, but for widening the road, my lord, limited interim order till my lord disposal.
possible.
No interim order can be granted.
76.
It's a public project, no interim order.
No public project. I at that threshold, my lord.
Consider within 1 month. Within 1 month.
Next month, the
Since the demolition is going on, let it be 1 month.
Well, Mr. Bandyopadhyay is well. তুমি আছো
Mr. Bandyopadhyay, will you stop the demolition for election? You will not.
No.
So the representation also should not stop.
It's a 75, 76.
Maybe.
The land acquisition. Then
But what about the RTI reply?
Yes.
I am putting this question myself.
Affidavit of service. The
Where is the notice of the demolition?
grievance of the
আরে
petitioner.
প্যারাগ্রাফে বলা আছে announce
But
করতে
there is no notice of demolition. It's only affirmation.
let it be recorded, my lord. Open, my lord, my announcing this, my lord, it has been, my lord, I have stated, my lord. কোথায় বের করেছে বলো
বললে তো হবে না নোটিশ নেই ডিমোলিশন তুই বলে দিলে আমি জানবো
আরে করছে দাদা কেন বলবো শুধু
If it
শুধু
is acquired, no notice is required actually.
I don't know what
They'll just.
it has been acquired already.
কি বলো? The grievance of the petitioners is that their land has been acquired by the respondents
থেকে নামানো ব্যাপার একটা থুপড়ে হয়ে আবার এপ্রিল মাস অথবা জুন মাস হয়ে যাও হ্যাঁ
for the purpose of construction of Pakka Road, namely road from Debra Debra to Shobong Mohar SABANG -MOHAR.
নোটিশে কোনো দরকার নেই যেহেতু
LA case number in bracket R and A bracket closed 252 of 1975, 1976 and LA case number 11 of 1979-81.
80 my lord 79 80
81 you've recorded it.
But
Paragraph
the page my lord page 56
Paragraph 3 of your writ petition.
my lord page my lord this is
79 80.
দাঁড়াও
79 80. The petitioners have not been paid compensation for the same till date. Stop. The petitioners submitted a representation in this regard before the concerned authority through their learned counsel learned advocate on
9th of October 2023, page 63.
on 9th October 2023, pursuant to which the additional district magistrate and district land and land reforms officer, Paschim Medinipur, by a letter issued on 22nd January 2024 to the executive engineer, Midnapur Highway Division, PW within bracket roads, bracket close directorate, Midnapur, and the special land acquisition officer, Paschim Medinipur, requested the latter, LATTR, to look into the matter and send an action taken report at the earliest. Stop. Paragraph. Learned counsel for the petitioners submits that the representation is yet to be considered. Paragraph. Learned counsel for the respondents submits that who should consider? The ADMDLLR.
DM.
Let the special land acquisition since it's payment of compensation.
Yes, yes.
The third respondent be directed to consider the representation in accordance with law. Paragraph. In view of the above, the writ petition is disposed of, directing the third respondent to consider and dispose of the representation submitted by the petitioners submitted on behalf of the petitioners, dated such and such, within 1 month from the date of communication of this order, upon affording reasonable opportunity of hearing to all concerned, including the petitioners, in accordance with law. Paragraph. In the event the petitioners are entitled to compensation, the said authority is directed to take all consequential steps for payment for disbursement of the same in favor of the petitioners within 2 months thereafter.
It is not already paid.
Yes.
If it is not already paid.
But that is why the action taken report was sought for. Otherwise, why should I file the petition? Deeply obliged.
Next.
But I beg to appear on behalf of the petitioners. The order of the district magistrate Nadia, being the land acquisition collector, is the impugned order before your lordship. The legality and the propriety. But the short fact remains that the two brothers who are the writ petitioner before your lordships happen to be the son of the deceased donor.
Serve the
Yes.
Gram Panchayat and the
Yes, yes.
private respondent?
But there is no private respondent. The respondent number, those 4 private respondents are the sisters of the brothers who are the writ petitioners. They have already sold.
Surveyor Madan Ghosh served.
But on the last occasion, my lord, your lordship expunged him. By earlier order, on the kindly come to the earlier order passed by your lordship at page 85. Since Madan Ghosh was not a party concern, my lord, not a proper party or non-necessary party.
That is in the earlier writ petition.
Yes.
Not in this writ petition. You have again implicated him in this writ petition.
But he can be expunged. Respondent number 8 can be expunged. May I just indicate to your lordship? The original owner was Gobindo Joardar. He has 94 decimals recorded in his name. By 2 deeds he purchased. He died, leaving behind the 2 writ petitioners who are the sons and the pro forma respondents who are the daughters. But after the death of the original Gobindo Joardar, the daughters executed a deed of sale in favor of 2 brothers who are the writ petitioner before lordship. But the entire property of 94 decimals stood recorded as per record of rights in favor of the writ petitioners. But thereafter, after getting the property from the father's demise, they got a measurement. They found that certain portion is there is less area of land on measurement. So they approached the concerned Gram Panchayat. Gram Panchayat appointed a Amin by making they made a measurement and found 0.06 decimal is less than what is recorded. Kindly see the map once. which your lordship will get.
Your earlier writ petition was on the same.
Yes, my lord directed to consider. On the basis of the available documents, kindly see the page 77 once. But this is the schedule of the land. On the right, on the left-hand side, your lordship will get the name of the owners, Ashish Jodhar and Bishwajit Jodhar. Your lordship has got it. Page 77. At the top left-hand side, name of the owner. The jail number given, plot number given. By two deeds, they got the property from their because the father has died. The sisters have executed the deed of gift in their favor. Total area they have got, and on measurement, on the remark column, it is found unauthorized acquired by the Gram Panchayat for road area 0.06 acres. The map measurement by foot. But this is the measurement that been given by the surveyor, who is respondent number 8. Thereafter, I made an RTI application to whether any land acquisition notification was ever issued. But to that extent, my lord, they, by a reply, page 82, said that with reference to above, in response to your application, you are apprised that this office is unable to provide acquisition related information without specifying LA case number. But for that reason, I approached before your lordship. My lord, your lordship's order is at page 85. Relevant portion is page 86. My lord, the third paragraph, which starts with upon consideration. Upon consideration of the submission made on behalf of the parties, the petition is disposed of with the liberty to the petitioner to submit a comprehensive representation ventilating the entire facts as contained in the writ petition before the second respondent within a week from date. The second respondent is directed to consider and dispose of the representation within a period of 2 months from the date of receipt, after granting disciplinary opportunity of hearing to all the interested parties, including the petitioner, in accordance with law. But this was the direction passed by your lordship on 11th of November 2022. But thereafter, I filed a detailed representation, which your lordship will get as page 88. I am not traveling with your lordship with the details of the representation being given. Kindly come to the impugned order at page 98. Page 99, the relevant portion is there. Let me kindly see the last but third paragraph. He starts with the BLLRO. But the DM directed the BLLRO to submit a report. The BLLRO Shantipur in his report stated that there is a road passing through LR plot number 2083, of which I am the owner. Mouja Govindapur PS Shantipur, which exists since 30 to 35 years. He has also stated that the petitioner or his petitioner never made any objection or protest at the time of construction of that road. Pradhan, as well as the executive assistant, stated that as per the demand and the requirement of the local people, this road has been constructed and nobody has made any objection in this regard. These are the submissions before the DM. It is admitted that the impugned order is in existence since 30 to 35 years and it has been used for public purpose. It is also admitted that the successor of the petitioner, that is his father, was the erstwhile owner of the land in question, and he never made any objection before any authority for such construction of the road, which has been used for public purpose. So it may be well presumed that the predecessor of the present petitioner voluntarily allowed of such land be for benevolent purpose. Such act of predecessor of the petitioner was an act of granting license, which can be implied from the conduct of the predecessor of the petitioner. Now, after 30 to 35 years, present petitioner wants the possession of the land. In my humble opinion, such inordinate delayed claim cannot be sustained in law. This petition is also barred by the principle of estoppel, waiver, and acquiescence. But my first submission is that you are in wrongful possession. If the state is a wrongful possession and it is a continuing wrong, the question of limitation does not arise. First. Secondly, they have not issued any notification under Section 4 that your land has been acquired. No assessment, no monetary compensation. But in identical situation, my lord, your lordship has decided a matter concerning Vidya Devi, taking into consideration Vidya Devi. The Vidya Devi also been subsequently been considered by another Supreme Court decision, which I will rely upon. 2020, Volume 2, SCC 569. First is that you have waived your right. Secondly, there is a limitation. My lord, on the point of limitation, my lord may kindly come to 12.12. Page 574. The contention advanced by the state of delay and laches of the appellant in moving the court is also liable to be rejected. Delay and laches cannot be raised in a case of a continuing cause of action, or if the circumstances shock the judicial conscience of the court. Condonation of delay is a matter of judicial discretion, which must be exercised judiciously and reasonably in the facts and circumstances of the case. It will depend upon the breach of fundamental right and the remedy claim, and when and how the delay occurs. There is no period of limitation prescribed for the court to exercise their constitutional jurisdiction to do substantial justice. My lord, in this case, my lord may kindly turns to paragraph 12.1 and 12.2. This was the observation of the Honorable Apex Court in 12. Which your lordship has followed in another decision of unreported. I will place before your lordship. Kindly come to 12.1. The appellant was forcibly expropriated of her property in 1967 when a right of the property was a fundamental right guaranteed under Article 31 in Part 3 of the Constitution. Article 31 guaranteed the right to private property which could not be deprived without due process of law and upon just and fair compensation. The right, paragraph 12.2. The right to property ceased to be a fundamental right by the Constitution 44th Amendment of 1978. However, it continued to be a human right in a welfare state and a constitutional right under Article 300A of the Constitution of India. Article 300A provides that no person shall be deprived of his property save by authority of law. The state cannot dispose of a citizen's of his property except in accordance with law, and the procedure prescribed by the law. The obligation to pay compensation, though not expressly included in Article 300A, can be inferred from that article. Now, my lord may kindly come to Article 12.11.
Yes.
We are surprised by the plea taken by the state before the High Court that since it has been a continuous possession of the land for over 42 years, but in my case, they have said 30 to 35 years. In that case, before the Supreme Court, it was 42 years. It would be a tantamount to adverse possession. The state, being a welfare state, cannot be permitted to take the plea of adverse possession, which allows a trespasser, that is a person guilty of a tort or even a crime, to gain legal right over such property for over 12 years. The state cannot be permitted to perfect its title over the land by invoking the doctrine of adverse possession to grab the property of his own citizen, and has been done in the present case. But in this case, identically situated, my land of Govinda Juardar stood in the record of rights for 94 decimal. When my sisters transferred their right in the favor of the petitioners, who are the two sons of the deceased Govinda Juardar, record of rights of 94 decimal stood in their name. So I have no knowledge I have no knowledge that any portion has been included or government has acquired any portion thereof by invoking Section 4 of the Land Acquisition Act. My knowledge only comes when I got the by deed of gift and make a measurement. For the first time that came to my knowledge, immediately I made an RTI to come to know that whether there is any land acquisition. They said no, there is no record. Thereafter, I filed the writ petition. My lord directed to consider. On consideration, BLRO submitted a report which says that there is a road existence. So BLRO admitted there is an acquisition. DM says, no, you waived your right by keeping silent for 30 to 35 years. Where is my silence? Because my records as on date of filing of the petition, 94 decimals stood in the name of the two writ petitioners.
When was the deed of gift executed?
My lord, deed of gift executed on. My lord may kindly come to page 33. 16th of November 2021. Kindly come to page 33 and page 52. 33 is the deed by the daughters of the deceased. 33. Yes. Kindly see the date. Additional District Sub-Register Shantipur Nodia, 16 November 2021. On this date, 4 of the daughters executed 2 different deeds in favor of the 2 different brothers, two brothers who are writ petition number 1 and 2 before your lordship. 16 November is the first deed in favor of Bishwajit Juardar, and the other deed is at page 52. November in favor of Ashish Juardar. Page 52. 33 and 50.
Dates are the same.
These same date. Now, my lord may kindly consider this Vidya Devi was also taken into consideration on a subsequent decision by the Honorable Apex Court in 2020, Volume 4, SCC 572.
Yes, paragraph.
Paragraph 15 and 19. But this was in relation to a Sikkim land acquisition. the relevant portion of the Sikkim land acquisition are in perimeter area to the Land Acquisition Act of 1894. It is also settled law that following the procedure of Section 4.1 of the Land Acquisition Act, akin to 5.1 of the said act, means the Sikkim land acquisition, is mandatory, and unless that notice is given in accordance with the provisions contained therein, the entire acquisition proceedings would be vitiated. The entry into the premises based on such non-compliance would result in the entry being unlawful. The law being expropriatory in nature, in character, the same is required to be strictly followed. The purpose of the notice is to intimate the interested persons about the intent to acquire the land. These provisions are read as they read of the said act, thus are required to be so followed. It is a mandatory requirement that you being the state, you cannot forcefully go into the land and grab the land without due process of law. Now kindly come to paragraph 19.
Yes.
The result of the aforesaid would be,
Let him complete, Mr. Dev. Let him complete.
the result of the aforesaid would be that the respondents have failed to establish that they have acquired the land in accordance with law and paid due compensation. In my case, no acquisition, no compensation. The appellant would thus be entitled to the possession of the land as also damages for illegal use and occupation of the same by the respondent for at least for a period of 3 years prior to the notice having been served upon them. So question, no notice has been served. So there is no limitation being comes into. It remains a continuous wrong for the period of last 30 to 35 years as reflected in the order of the district magistrate. We are strengthened in our observation on account of the judgment of the case of a land acquisition officer, M. Ramakrishna Reddy, wherein it has been held that the owner can be entitled to damages for wrongful use and possession of the land in respect of which no notification is issued under Section 4 of the Land Acquisition Act from the date of possession till the date of such notification is been finally published. Well, identically, my lord, your lordship has also passed a judgment. It is a report decision. Kindly see, my lord, this is the decision of your lordship.
Mr. Dev, let him complete his submission. Let him complete his submission.
Paragraph 17.
17.
17 of your lordship decision. Passed in Sucharita Roy. Following Vidya Devi, your lordship has passed this judgment. It is a trite law that the right to property is a human right in a welfare state and a constitutional right under Article 300A of the Constitution. No person can be deprived of his property by anyone, including the state, except in accordance with the procedure established by the law. The authority in Vidya Devi, SUVRA, says that in such a case, the obligation to pay compensation, though not expressly included in Article 300A, can be inferred in that article.
State filed an appeal.
I am not on this point.
Following the, may I just continue?
All these quite adverse position, they not say that is the adverse position. And all the judgment is not absolutely in this case as because the lordship page 99 last paragraph. Page 99, your lordship will see last paragraph. It is admitted fact that the improved road is in existence since 37 and this is being used for public purpose. It is also admitted fact that the successor of the petitioner, or that is his father, was also a owner of the land, and he never made any objection for such construction of road which is being used for public purpose. So it may be well presumed that the predecessor of the present petitioner voluntarily allowed for use of such land for benevolent purpose. Now, next page. Such act of predecessor of the petitioner was the act of granting license can be implied from the conduct of the predecessor. That now after 35 years, present petitioner wants permission for the land. By Amplity, such denominated delay claims cannot be sustained in law. Part for the petitioner. Whether these two paragraphs, my lord, is according to the provision of law. I say no. So my lord, those judgment, my lord,
And admittedly, the road has been utilized.
So
Yes.
the petitioner must get their compensation. It is not, my lord, that they automatically, as after 35 years, the petitioner files an application, that is not getting the money. He must get the money. In every case, my lord. My lord, for that is, my lord, these two paragraphs is, my lord, not. I can support these two paragraphs. These two paragraphs is not, my lord, according to the provision of law.
So,
and if my father never, my lord, claim for the compensation, for that is, my lord, the sons where they are claim that.
do you propose to purchase it directly?
My lord, I can't, my lord, my lord, that
Will you take instructions?
My lord, that again, my lord, consider that three parts.
Reconsideration will not help, Mr. Dev. It has to be, there are two options. Either the 2013 Act.
Is, my lord, purchased by the Pradhan. I am not for the Pradhan. My lord, Pradhan, my lord, that road was utilized by the Pradhan.
Utilized by the Pradhan.
My lord, Pradhan will pay the amount. There is some money, and Pradhan will pay the amount. I am not for the Pradhan.
My lord, I have served. I have served Babla Gram Panchayat. Pradhan of the Babla Gram Panchayat.
I can't.
Respond number 6, my lord, may kindly see.
That process.
Respond number 6, I have served.
6 and 7.
Yes. One is the body and another is the head of the body.
Then I can say something. I am not against the petitioner. You take the money.
It is served.
I have served, my lord, long back. আর কোথা দিয়ে ধরবো স্যার ওকে আমি আর কোথা দিয়ে ধরবো স্যার
He is the answering respondent. So,
but the order has been passed by the DM and Pradhan was present before the DM. Kindly see the order.
Yes, my lord, I have seen.
So DM asked the BLRO as well as the Pradhan to remain with the records as well as their findings. On the basis of the findings of the two persons, BLRO and Pradhan, DM has passed this order.
finding is bad, but then I will not send it back for reconsideration because that, again the same finding will come.
Yes, I'll be returned with the same
There are
finding.
two options, Mr. Dey. Either the 2013 Act you have to acquire, or you have to go in for direct purchase.
Pradhan is the utilized, my lord.
The Pradhan will give the money.
It is utilized by the
Pradhan cannot acquire, Pradhan cannot purchase directly.
Yes, madam. Pradhan can purchase directly.
The state will do it, Pradhan will pay the amount.
And my lord, if Pradhan utilize the land, he must pay that.
Pradhan is a creature of the statute. Whether the Pradhan will give or the DM will give the money through Pradhan.
He is not representing the Pradhan. That is the difficulty.
But the Pradhan has been served, my lord. If the Pradhan does not represent before your lordship,
I can, my lord, admit that position, my lord. Allow in favor of this Pradhan.
Will you just intimate the Pradhan that it will appear on another date? Because the Pradhan's presence is necessary. Otherwise, it will not serve your purpose.
my lord, they let the submission be recorded, my lord. On the last occasion, it will be beneficial for your lordship.
Affidavit of on prayer of the.
My submission may not be.
No, I know. On prayer of the petitioners, the name of the 8th respondent, Sri Madan Ghosh, be expunged from the cause title of the writ petition. Stop, the cause title be amended accordingly. Please do the corrections today.
My lord, I will.
Paragraph affidavit of service. None appears for respondent numbers 6 and 7 despite service. Paragraph. It is submitted on behalf of the petitioners that upon demise of the predecessor in interest of the petitioners, who was the owner of the land in question, comma, the pro forma respondents, who are the sisters of the petitioners, have gifted the land in favor of the petitioners, vide deeds dated 16th November 2021. Stop. Upon acquiring title in respect of the entire plot, comma, the petitioners conducted measurement of the plot by a surveyor and found that the quantum of land in possession of the petitioners is 0.06.
0.94 in the position of the petitioner.
No,
0.06 has been acquired. 0.06
0.06 is 0.06 acres less than the quantum recorded in the record of right.
My God.
Pursuant to an order passed by this court in WPA 15907 of 2022 on 11th November 2022, comma, the petitioners submitted a representation in this regard before the concerned authority. Stop. You were heard by the authority before the order was passed?
Yes.
The concerned authority, being the district magistrate, comma, Nodia, disposed of the representation submitted by the petitioners by an order passed on 3rd August 2023. Turning down the claim of the petitioners. Stop. The said order is impugned in the present application. Paragraph. It has been admitted by the authority that the father of the petitioners was the erstwhile owner of the land in question, which has been utilized by the authorities by construction of a road therein, before about 30-35 years. Stop. Strangely, comma, the district magistrate has observed that since the petitioners, etc. father did not raise any objection against such utilization, comma, it may be presumed that he voluntarily allowed the respondents to use the land for the benefit of the public. Also, comma, since no objection was raised by the original owner of the land, comma, the petitioners were not entitled to raise such objection after passage of 35 years. Stop. Such observation is unknown to law. Stop. Paragraph. It is trite law that in case of a continuing cause of action, comma, the land losers cannot be deprived of compensation merely because of passage of time. Since admittedly the land of the petitioners has been utilized by the authority by constructing a road therein, comma, the petitioners are petitioners advocated in, it is incumbent upon the authority to either compensate the petitioners in terms of the right to fair compensation and 2013, or propose direct purchase of the land from the petitioners at the present market rate. Paragraph. Since the fifth and sixth respondents who have admittedly utilized the land in question, 6 and 7.
6 and 7.
6 and 7, who have admittedly utilized the land in question are not represented, comma, the petitioners are directed to serve notice upon the said respondents, intimating the adjourned date. Paragraph. Let the matter appear under the same heading on 12th April.
What intelligence is that lot of 684 lot has been 11th April. So, occasion of holiday for legal purpose.
Not declared. And we do not need
calendar, but in my calendar it is not.
Oh, the moon can say. None of us can say.
In regard to item number 689, there was a only a single.
The clock is running. Next day.
In this matter, I am appearing on behalf of the petitioner, Personal Lordship Petition. I have served the copy to all the valid contemners. Just I have informed that order has been complied with. So I am praying only for not today, so that I
Order
can
has
take
been complied with.
according to my learned friend. So I have not seen the report because I have to depend on my learned friend, sir. Yes. Yes. Please,
So only not today, because since it has been complied with.
No, আমি একটু দেখবো not today চাইছি।
He wants to go through the report.
Yes, yes.
Lordship, kindly have a look. My lord's
Report.
order first. Whether if
Report
there is a
compliance. Affidavit of compliance দিচ্ছি। And record আজকে ফাইল করছে না।
Because my
There is your affidavit of compliance.
My submission today before your lordship is the first day after mother serving the copy. I'm the compliance report, yes. Although
No, it has to be an affidavit.
yes, there is no such order till date. First of all, my submission is that there is contempt. Number one, because there was no such order either in a positive manner or in a negative manner directing to do something or not to do something. If a lordship kindly, my lord, come to your lordship's order at page 161 publication. Can any contempt application be, my lord, be taken up on the basis of, my lord, that non-compliance of this order? Then I am coming to it that with regard to that steps have been. So kindly go through my lord's order 161 and continue to 162.
Yes, so there is no order at all. Where is the contempt?
Order means the government GO in terms of the government GO.
Contempt arises for non-compliance of an order of the court.
But till date, my lord, this
Not maintainable.
GO has not been complied with.
Not maintainable.
Because I have annexed the my lord, documents, latest document photograph without registration, my lord.
Irrelevant. You have to file, come before the court if it is not complied with. The order under contempt has no order at all. There is no direction.
Just quoted the government.
Yes, so that is not a direction of the court.
Writ petition.
That is not a direction of the court.
To avoid the further litigation, my lord, to avoid the multiple writ petition.
The scope of a contempt application is very limited, you are aware. It's not maintainable.
Contempt is serious.
Or liberty to move face to
But not in contempt.
Not necessary. That is a fresh cause of action. You have the liberty.
Can come up for
But because as per GO, my lord,
affidavit of
petition has not been taken.
Paragraph. It appears from the order under contempt dated 15th September 2023 that no direction was given upon the respondent authorities. Stop. The writ petition was disposed of upon recording the relevant portion of a memo issued by the Secretary, Transport Department, Government of West Bengal on 5th September 2023 to all district magistrates. Paragraph. In view of the above, the contempt application being CPA and such is dismissed, being not maintainable. There shall, however, be no redress to costs as in such a paragraph.
Well, liberty, kindly at least.
You have the liberty.
Because,
It's a fresh cause of action.
To avoid the multiple proceedings, my lord, then I can.
It's a fresh cause of action. Yes.
Kindly sign all the objection.
Not
The fresh
necessary.
cause of action, nothing else. Only kindly.
Not necessary.
liberty to what?
Next matter.
Yes, awesome.
For the petitioner, my lord, lordship will be kind enough to recall lordship's order on 9th of January 2024.
9th of January.
9th of January 2024, lordship has directed them to file some documents pertaining to the issue whether the actual possession was handed over to me prior to 2019 or not. But that is a very crucial document, or else my contention, my lord, for commencement of business, which is also another clause in the letter of allotment, shall be taken into account.
I have instruction, but you will be directed to file a report in the form of e-mail. That officer.
Very specifically, you were directed to file documents to substantiate that possession of the area was made over to the petitioner prior to 30th July 2019. That was the direction.
Yeah, document, as far as the ABDB is concerned, that is not.
Where is the document? Please show me. The particular document, not that bunch. Please show me the particular document.
The document, one page, the supporting papers is here.
No.
Only one.
The one, there should be one document showing that position was handed over before 30th July.
Can you see?
Can
you see?
আমাকে একবার দাও একটা কপি দাও
There is one single line that the possession was handed over before 30th July. Where is that line?
And see that independence of the above information that the application was handed over.
Mr. Chakraborty, I will not see anything. There was a direction of this court. I want to see compliance.
Yes.
That I have.
Please show me that particular page.
Enclosure A.
Does enclosure A say? Yes, what does it say?
For allotment of space for modular capacity store, number 1 at Asansol 5 area near Boston, reservation of DB. In view of this subject, the sketch plan going, that is stated color, that is 4th of March 2019.
Mr. Chakraborty, please go through the order passed on 9 January. Please go through the order passed on 9 January. This is only beating about the bush, nothing else.
Only such document that some position has been
You
taken.
have handed over possession prior to 30th July.
Yes.
That is your case. Where is the document?
That is the document, madam.
Which is the document to show that you handed over possession before 30th July?
That is dated March 4th of March 2019, madam.
This is issue of sketch map.
Yes, madam.
Where is handing over possession? I mean, I believe this is all English.
Yes, that is I also understand. But as per their version,
I am not concerned with their version at all. I have passed an order. Please comply with it to avoid contempt. I take serious exception to this. It may be that the authority has no document in support of his case. I'll hold this.
Because, my lord, if I say one thing,
map and position letter.
Has the court asked for a sketch map?
Yes.
No. One document showing that you have handed over possession prior to this date, 30th July.
That is the position letter.
No.
Which is the possession letter? This cannot be the possession letter.
Plan allotment of space. That is position.
Allotment is not possession. No, not at all.
That
Allotment is when the letter of allotment is issued. And possession is when physical possession is handed over. They are absolutely two different things.
because, my lord, in the report, they have annexed few documents which they themselves have said that their own department occupied that particular area till 2020 and onwards for their own development work, for which the possession could not be handed over. And I also made several representations to them to hand over me the possession.
The report, in fact, admits that the operation has started
Yes,
for comments from
and they
22nd
themselves have
August
stated.
2021.
Yes, that is my contention. Accordingly, that, my lord, the agreement has to be from that particular date.
Yes.
But that document is crucial. So far as my learned friend's contention is that they have given me the possession,
yes,
but they could not.
They've given possession prior to 30th July. That is your case. So there should be a document of possession prior to 30th July. Where is it?
Let them file an affidavit in the form of report, my lord, short affidavit.
Yes, next day if the report is not there, I have to hold against you.
Because,
Please
my lord,
inform your
so
authority
far
this
the
is a caution.
documents available on records are concerned.
This is a serious warning from my side. I will not tolerate this on the next day. Report in the form of an affidavit. With the relevant document, I'll dispose it of on the next date.
Because, my lord, here nothing is an appended except the agreement, the copy of the agreement is there, and the sketch map.
No, that's the reason why the authority is not coming up with
Because
document.
the
There is no document at all.
authority has appended documents, my lord, which shows otherwise.
Let them come. Your interim order will be extended.
Yes, ma'am. Great.
Learned counsel for the respondents seeks extension of time to submit the report in the form of affidavit as sought. Paragraph, let the matter appear under the same heading on 19th April. Please serve an advance copy, Mr. Chakraborty.
I think some holidays is here, man.
No.
No, 19th April I've said.
Monday.
19th April, Friday, my lord.
Yes. 19th April.
April.
Not next Friday.
No.
Wake up, Mr. Chakraborty. What is wrong? Yes, 17th April. So, 19th is not 17th. You're speaking like your authority. 30th July is same as this, and now you're saying 19th. 19th is 17th.
Holiday,
17th is not a holiday in this country.
Do
we have a holiday for Ram Navami? No.
No, it has been declared. It has been declared.
State declared. We are not the state.
No.
Then, no difficulty at all.
Probably,
The
my lord,
interim order paragraph, the interim order granted earlier is extended till 31st May 2024 or until further orders, whichever is earlier. I have already done.
Grateful.
Next court matter,
Similar matters.
Next day, I'll dispose of all these matters.
Yes,
Let
ma'am.
me assure you.
I also,
And it will go against you because you have no document.
but that is a document, I think so. I have inquired all the things, that is the final document.
This is still 799.
Nine.
Same
All
order?
5 matters are same, man.
98.
98.
Till 798. 799 is also your matter, so I was confused. Till 798, same order. 94 to 98.
I miss.
পরেরটাও তো আমার। There's a Which I am for the petitioner, my lord. This is a matter, my lord, will remember.
Respondents?
Yes. I have completed my submission, my lord. I have also handed over the authorities. Roshi has taken note of that. And Roshi, they have to submit right now.
Yes. Passover is not possible in this court.
Not today, no?
Yes.
In court number 30.
Is engaged, bolo. Busy, bolo.
On prayer of the respondents, the matter is adjourned. Paragraph, let the matter appear under this on the same date, 19th.
19th or, my lord, any day subject to lordship. Because interim order is there, my lord, till 31st March.
I'll extend it.
Lordship extends it, fixes any day.
19th.
20th is Saturday.
20th, which month? 1 minute, which month? 20th?
20th.
Have you heard what I've said?
Wednesday,
Yes?
next Wednesday, 20th March.
Have you heard what I've said? No. You're making a submission without hearing me. Let it be 12th March. 12th April. Sorry. 12th April, Kurun. Paragraph, the interim order granted earlier is extended till 31st May or until further orders.
Great.
Or whichever is earlier.
I'm strict respondent with Mr. Devra.
Mr. Devra is there, yes. We are audible?
Yes, yes, audible. Audible.
Petitioner, your appeal.
Practically, my lord, this matter, Lordship already heard, and Lordship going to dismiss the writ application. My lord, when my learned friend, my lord, took time for adjournment. It's a offer letter, stipulated offer letter condition is the offer letter, 6 months, automatically cancelled. He wanted to, he made a prayer after the expiry of that period. That is not acceptable. And he made an allegation, the permit granted to some other person, that is also not correct. Lordship kindly.
জজটা ডিসমিস করছিলেন আগের দিনে মামলাটা, এই মামলাটা ওই যে পান্টুদা বলছেন ডিসমিস করছিলেন জজটা।
Mr. Debra, according to you, the vehicle was not placed by the petitioner.
Yes, within the time.
Yes, Mr. Bhatt.
My, in this matter, my lord, my writ petition has been filed on the twofold grounds. First of all, I have made for this particular route permit 3 applications. My first application was approved. Offer letter was issued. I submitted a letter that I have purchased the chassis and I am ready to place the vehicle. So kindly extend the offer letter. Extend the validity period of offer letter, because initially the offer letter was issued for a period of 30 days only. I applied before the authority for extension of that offer letter. No answer in that application for extension. No answer. No response. After that, after getting the vehicle ready, I submitted the papers of the vehicle. Without considering my representation, without rejecting my applications, they placed the matter before another board meeting for grant of matter, without cancelling my offer letter, without disposing of my representation. In that offer, my second application was not rejected. Second application kept pending. The third application, I was constrained to file third application on this particular route on the plea that the offer letter would not be, permit would not be granted in terms of the offer letter in respect of my first application. But the third application has been rejected on the purported plea that my application is later than the my application was filed later than the grantee. Grantee is the respondent number, private respondent.
Who is appearing for the private?
I served evidence service, they didn't choose to appear. My lord, your lordship was pleased to pass an order on this aspect that first in, first out method has no basis at all. And your lordship rejected that proposition. That first in, first out has no basis at all in respect of the grant of permit. So, in the latter on, my lord, the last impugned decision, whereby my application has been rejected, since my application has been filed after the application file of the grantee. Well, that part is, my lord, in my favor, perhaps, my lord, because my lord, first in, first out, your lordship has also been negated. I have got your lordship's order also. Well, so far, my lord, first application is concerned, my lord. I am humbly submitting before your lordship, but in the earlier occasion, I have submitted one judgment passed by the Honorable Justice, the Honorable Justice Bhaskar Bhattacharya, that after the offer letter, if in the offer letter, in respect of the offer letter, petitioner submits, operator submits a vehicle. After that period, that vehicle, that application ought to have been considered. Another order has been passed by your lordship. Your lordship kindly have. আচ্ছা আগে না জজটাকে আগে দেখাই। এর সঙ্গে একটা এক্সট্রা এইটা একটা এক্সট্রা কপি আছে দেখ
এটা এই বিটটা
Your application for extension was within 30 days.
Yes, my lord. That is, my lord, page 55. Offer letter টা কোথায় গেল? Offer letter টা কোথায় গেল? Offer letter টা।
When was the offer letter issued?
My lord, offer letter was issued, my lord. That is page. My lord, page 64. Page 64, 18th October. And my prayer, my lord,
April 23 was your deadline, 6 months.
my lord, here, my lord, your lordship, only 30 days. My lord, your lordship, can page 64.
30 days, you sought an extension of within 30 days.
Within 30 days.
You could have got only another 30 days. The total period is 6 months.
My lord, your
180
lordship,
days. Total 180 days, my lord.
180
It is in the offer letter specifically mentioned in case he has failed to produce any document within 180 days, offer letter automatically cancelled. Lordship kindly said no question of further communication is required. My respectful submission, my lord. The offer letter bottom portion, Lordship kindly see.
my lord, I have had
Here it says 30 days.
Offer letter last portion, my lord. There is a clause. Next page, my lord. That is the last portion of the offer letter.
Yes, it says 30 days, not 180 days.
What specifically mentioned, my lord? Lordship kindly see. Terms and condition of the offer letter. Lordship kindly see. Next page. Last line. Please note that failing to submit relevant documents as aforesaid within the stipulated period of 180 days from the issue of this offer letter will automatically lead to the
in the last
liable
question,
to be
I
stand
could not
cancelled.
hand over the order passed by the Honorable Justice Bhaskar Bhattacharya. But now I handed over. Your lordship kindly have a look at order.
Yes, but the order
It has been settled.
Order also says maximum period of 180 days.
My lord, your lordship, today I have
After 180 days they come.
Today I have handed over, my lord.
And
Yes.
rule
16612. Read petition number 16612.
16612.
And my lord, page 2, my lord. Page 2. My lord, starts from, my lord. My lord, this is no dispute, my lord, that before the expiry of the said 30 days, the petitioner applied before the respondent authority for extension of such date. But such application for extension has not been disposed of before expiry of the said 30 days. The question is, if such application is kept pending for an indefinite period of time and in the process 6 months expires, whether the respondent authority can claim that the original offer letter issued has already stood cancelled, and as such authority is under no obligation to dispose of such application for extension. After hearing the learned counsel for the parties and after going through the aforesaid provision contained in the West Bengal Motor Vehicles Rules 1989, I find that once an application for extension of time to produce the ready vehicle is filed, within the period of 30 days from the date of receipt of such offer letter, the respondent authority is under obligation to dispose of such application either by rejecting such application or by allowing the same. But without disposing of such application in either way, after the expiry of the period of 30 days, the state transport authority cannot claim that the offer letter has in the meantime stood cancelled and it is under no obligation to dispose of such application. What my learned senior friend submits that. In my view, if any application for extension of time to produce vehicle is filed before expiry of 30 days, what I have done, for instance, on X day, in such a case, if such application is even dismissed after the expiry of 30 days, the respondent authority should permit the petitioner to comply with the terms mentioned in the offer letter within the period of 30 minus X days after communicating of such order of dismissal.
After this,
No communication has been passed by the authority till date.
please read the remaining.
Yes, my lord. After communication of such order or dismissal. However, the maximum period of extension being fixed by the statute and the set period being 6 months, the petitioner can in no case get more 6 months time even if such application is not disposed of, and in such a case before the expiry of 6 months, he must convey to the state authority that he has complied with the requirements of the offer letter within such period. Therefore, if the petitioner within 6 months from the
So
expected
have you
time,
complied with this part? Even if the extension petition is not disposed of, you cannot get more than 6 months.
now you're lost. Now, I'm obliged. But therefore, if the petitioner within 6 months from the expected time fixed by the offer letter produce the papers relating to the vehicle as per directions and leave that by time, and application for extension is not disposed of, though filed before the expiry 30 days, such application should be accepted as a matter of course in view of the fact that even on that date, if such application is rejected, the petitioner will get further 30 minus X days.
Have you produced the relevant papers before the authority within 6 months? Where is that document?
My humble submission, if you lost it, I could not. As because my application for extension of time has not been disposed of.
So the judgment is against you.
I am. In such a situation, that state authority cannot claim. In such a situation, in such a situation, the state authority cannot claim that it is under no obligation to dispose of the original application for extension, since the period of 30 days mentioned in the offer letter has expired, and consequently the offer letter has elapsed. But applying the aforesaid principle to the fact of the present case, I find that the petitioner has complied with the requirement, and it is only for the state authority to decide whether the vehicle is strictly in accordance with the terms of offer. If the vehicle conforms to the terms of the offer, if the vehicle, the state authority should grant permit to the petitioner within 7 days from the date of communication of this. My vehicle is conforms the offer letter. Provided the petitioner has complied with all other terms of the offer letter. However, delay will not stand in the way of the petitioner in getting permit. And it should be presumed that he has complied with all terms within the time fixed by the original offer letter. I, however, make it clear that if and in view of the decision of the division bench of this court in a given case, compliance of Bharat State, that is not applicable. In case any order is passed rejecting the application for extension without granting, so my lord, delay is not a fatal. Whether the vehicle produced by the petitioner is conforms to the offer letter or not, that is to be looked into by the authority. In case any order is passed rejecting the application for extension without granting further 30 days, for compliance further 30 minus X days, for compliance with the condition of the original offer letter, such order should be deemed to have been set aside by this order. So, my lord, I should have been granted the time beyond 180 days, my lord.
There is a condition to this. If you would have produced your vehicle along with the relevant documents before the authority within 6 months from the date of issuance of the offer letter, even if the authority would have not disposed of your application for extension, it was to be considered. This is the principle laid down in this judge. That is the proposition of law.
No, so far the delay is concerned, my lord, your lordship.
Have you delay is concerned? That is the direction of the court. Since you submitted the document in this matter, the petitioner submitted the documents and produced the vehicle within 6 months. Yeah. So the authority was directed to consider. But in your case, After the extension application was filed, you have not taken any further steps. Page 63 says that you have submitted you have filed this application beyond 6 months. Page 63.
Yes, it is not disputed, my lord. It is not disputed.
So
My humble submission before your lordship
not be considered.
cannot be considered.
Please come to this paragraph. You are relying on a judgment which goes against you. Page 3, first paragraph, last few lines. However,
The maximum period of extension by the statute status at the statute being 6 months. The petitioner can in no case get more 6 months time even if such application are
even
disposed of.
if the application is not disposed of. Now, before the expiry of 6 months, he must convey to the authority that he has complied with the requirements of the offer letter, which you have not done.
My lord, so for my satisfaction, my lord, page 4, my lord, page 4.
Yes, page 4.
Applying the aforesaid principle to the fact of the present case, I find
this case where the petitioner had filed the documents within 6 months. That is the difference. Petitioner has complied with the requirements. You have not. Yes.
Getting the vehicle ready, my lord, I immediately submitted the same.
That was after beyond 6 months.
That is beyond 6 months.
So it was automatically
My lord, I skip over the first application, my lord. So for my third application is concerned, so for the impugned order is concerned is subject matter in this matter, my lord.
It is only one offer letter. 3 offer letters were not issued.
No.
Only one offer letter. So the time starts from the offer issuance of offer
After
letter.
the cancellation of offer letter, vacancy is 1. After the cancellation of my offer letter, vacancy is 1. Against that application, I made third application. This is the subject matter of this.
When you made the application, there was no vacancy because the private respondent was granted already.
No, my lord, there was a vacancy. There was a vacancy. In respect of one vacancy, my lord, 2 applicants was there. One is my client and another is the private respondent. Supplementary affidavit. Your lordship kindly have the supplementary affidavit. Supplementary affidavit, page 12. Well, after the filing of the writ petition, this order was issued. This resolution was issued, my lord. I'm sorry for giving you your lordship travel.
Page 12.
Page 12. This is the subject matter of this petition, my lord. Improved resolution. But there is 2 applicants.
Yes.
Board meeting dated 18th August 2023. 2 application, my lord. Vacancy is 1, my lord. Route details. 8 column. Vacancy, my lord. Route details, column number 8.
Yes.
Vacancy is 1.
Yes.
Application received 2. Now, my lord, what is the consideration? To Samuli Poribahon first, Mrs. Adasoki Transport, my application was filed on 20th April 2023 and his application is 4th April 2023. What? One quota was vacant for the instant route. Members of the STA board considered and allowed the earlier application of Mrs. Samuli Poribahon Private Limited. No consideration, no board seat, nothing. He has been directed to produce appropriate vehicles, no vehicle has been produced. Whereas my vehicle is still standing before the authority. So in this resolution, my second application and third application disposed of. Second application rejected, that there was no vacancy and it was a mistake in earlier resolution to decide that my third application, since it is latter application, my application is rejected only on that ground. No further ground is there. Whereas my lord, I produced the vehicle. My vehicle is still standing my lord, on June 2023, from June 2023 before the authority. And from June 2023, that vehicle is still been idle. And vehicle confirms the offer letter. BS4. Now, my lord, your lordship kindly have a look. The very guarantee of this route, my lord, against my lord, no vacancy, my lord. Siliguri to Ranchi, no vacancy. Page 14. So on this date, my lord, on 30th June 2023, my earlier offer letter was not rejected. My earlier application was not rejected. First application, just my first application.
30th June is automatically rejected because it was beyond 6 months.
I admit,
Authority
I
could
admit,
not, could not have done anything.
but on 30th June, my lord, vacancy is 0. But serial number 80, page 14.
Yes.
Vacancy 0. On 18th August 2022, page 12, vacancy 1. Before that, my application or first application was rejected. My offer letter was rejected, assuming it. Now, my lord, your lordship kindly come to the page 15.2. My lord, there is an FIR against the very grantee for a alleged scam of 70 crores, my lord.
Against whom?
Against the grantee, private respondents, for defrauding the authority against the challan, my lord. Your lordship, the name of the grantee stands in serial number, my lord. 1, page 21. This is the FIR, page 17, by the same authority, this FIR.
That is neither
17, 19, and the name of the grantee, my lord, 1, 2, 3, 4, 5, my lord, in each and every occasion, up to 6. So he, in any event, my lord, he should not deserve any permit, my lord. He should not deserve any grant. And this case is still pending.
Let us ask Mr. Vibra. Yes, how do you deal with this FIR?
Well, FIR, I cannot do this. This is the police authority. He can access, he can proceed with the FIR. Then he has to file a case before the criminal court, not before your lordship, my lord.
No, your authority lodged an FIR against the private respondent in 2022 and granted permit to the private respondent in 2023.
No permit has been granted. My specific
Granted,
instruction,
not issued.
Not.
My lord, resolution
Lordship
says
can
that it
record
is
it.
granted.
Lordship can record it, my lord. It is my instruction with me, my lord.
My lord, application, he is considered and allowed the application.
Yes.
Application allowed, he has been directed to
Can
obtain
challenge
offer.
this in a separate proceedings, not these proceedings. His application was there, considered, offer letter was issued within the time.
Application,
Lordship,
the FIR of the authority
I
should
am not
be taken
disturbing.
into
I am not
consideration.
disturbing Mr. Bhattacharjee. Offer letter was there, granted by the authority, and specifically stated that after 180 days, it is automatically
That
cancelled.
is good. That chapter has gone. That chapter has gone. That chapter has gone.
You please.
Mr. Debroy, first 2 applications were correctly rejected. He did not comply with the terms within 6 months, so they were automatically rejected.
My lord.
There was a 3rd application by the petitioner.
My lord.
My lord, please come to page 12 of the supplementary affidavit.
Yes.
2 applications, one by the petitioner and one by the private respondent.
Private respondent.
1 vacancy.
1 vacancy, private respondent was granted.
Resolution says private respondent was granted. No reason assigned for it.
Yes.
Private respondent also did not have a vehicle. He is directed to place a vehicle.
Yes.
The same resolution.
Lordship, may I submit one thing, my lord? That will solve the problem. My lord, without interfering the Mr. Bhattacharjee right now. When I'm try to solve the problem, otherwise it will continue.
Yes,
My lord, as a matter of fact, my lord, till date, my specific instruction is that private respondent did not produce any vehicle or anything like that, no permit has been granted by the authority. Sir, question of granting further, no. There is one vacancy still alive. In case private respondent grant, one vacancy still arise.
No.
So, in private respondent, Lordship can direct the authority to take steps against the private respondent for non-protection of the vehicle, or anything more, anything like that. Lordship knows.
Could direct that.
Anything.
Your lordship have been
তুই বলতেই না দে
self-same resolution has been rejected by rejected by your lordships in the earlier occasion.
Here case is different. After 6 months,
application, fast application.
His
Your
case is
lordship
started.
So, Mr. Debra said that till date, the private respondent has not produced any vehicle.
Yes.
So again, on the same principle, it automatically gets rejected.
Yes, my lord, my lord.
The vacancy remains. Yes. So file an application before the.
But that my application is still there, my lord.
No, no, no.
Your lordship kindly consider
No question
that
of
my
still
application
there,
has
my
been
lord.
rejected
He
on,
has,
on a flimsy
my lord,
ground.
authority will notify. Lordship kindly
application has been rejected on a flimsy
authority
ground.
will notify. He will apply.
Rejected.
But it has been rejected on a flimsy ground that has been set aside by your lordship, my lord.
No, no,
Lordship
lordship
kindly have a look at the order.
কথাই বলতে দেবেন।
That order has been set aside by your lordship.
Problem
In
হয়েছে
self-same aspect.
ও একাই বলবে, কার কেউ বলতে পারবে না।
Self-same aspect, my lord. Self-same. Your lordship kindly have a look at the order.
Nobody.
Self-same aspect.
Neither honorable judge nor me.
Fast in, fast out basis.
This is not a question of fast in, fast
Yes,
out.
my lord.
Yes.
Letter application. Letter application.
On supplementary evidence for
Resolution says the letter application.
This resolution doesn't have any force at all on
Development.
date because 6 months have passed and no vehicle has been produced. February.
No offer letter was also issued.
In case of Mala future vacancy
No, offer letter was
arises,
also issued.
he will apply. He will
No.
apply. Let him.
It's issued.
No, no, no. No permit has been issued in favor of Shamoli Puri.
No offer letter.
Offer letter has also not been issued.
Offer letter not been issued. My specific
So, my
instruction.
lord, your lordship kindly set aside this improved resolution and could direct them to reconsider my application.
No
my lord.
question of reconsider. You have to apply afresh. Unnecessary harassing.
This
the people,
application, this my lord, resolution is
the
on a
people,
flimsy
harassing
ground,
the
my lord.
honorable judges, you are trying to dismiss this.
Completely on flimsy ground.
No question
No
of
ground at all. No reason at all.
You have reason at all. Reason with the offer letter. You go through your offer letter.
There is no offer letter, Mr. Debroy.
No, offer letter, there is condition. Within 6 months.
That part is over. The previous two applications have been rejected correctly, rightly.
On the basis of, and regarding last application is concerned, he has to file a fresh application
No, my
when
lord.
the vacancy declared by the authority.
Why, my lord, I shall file again? My lord, again, my depositing the fees, my lord.
Yes, 2,000 rupees, what remain?
2,000 remain is not
Mr. Debra, let this be reconsidered.
Yes, my lord.
The third application.
Third application.
First two have been rightly rejected.
Yes, my lord. Deep level.
Yes, that is admitted.
My lord.
Yes, my lord. Deep level. And your lordship has already been hold up that fast in, fast out basis is not a basis at all.
That is also not stated here.
Yes, my lord. Letter application.
This is not his case. This is not his case.
Means, my lord, I have applied after the application of the grantee.
I have allowed the earlier application.
Earlier application.
Anyway, heard learned counsels for the parties.
In this case also, they applied the fast in, fast out method, my lord. Only fast in, fast out method. The page you just have hold.
It is
If I had to,
settled law as also laid down by a coordinate bench of this court in an order passed on 24th November 2003 in WP number 16672. 16672 within bracket W of 2003 that the maximum period of extension fixed by the statute is 6 months from the date of issuance of the offer letter, and the petitioner can in no case get more than 6 months' time, even if his application for extension of time is not disposed of by the authority. Stop. The petitioner has to place his vehicle along with, has to comply with, has to comply with all the requirements of the offer letter within the period of 6 months for the authority to consider his application. Stop. In paragraph, in the case in hand, comma, it is not in dispute that the petitioner did not place the vehicle or the relevant documents thereto before the authority within 6 months from the date of issuance of the offer letter. The offer letter was issued on 18th October 2022. Stop. The petitioner was ready to place his vehicle before the authority only on 8th June 2023, comma, that is beyond the stipulated period of time. Stop. The two applications seeking grant of permit filed by the petitioner were turned down by the authority
in any event, my lord, application for extension ought to have been disposed of by. But so no question at all, my lord, in this case. But that is to be disposed of by the authority.
ought to have been disposed of, provided.
Now within the stipulated period.
But here you have not done that.
Now within the stipulated, that ought to have been disposed of by them.
This says even if it is not disposed of, you
No,
do
no,
not
I am
have
not
more than
in
6
my
months.
case. I'm not in my case, my lord. If any application is made, my lord, within the period, my lord, that application ought to have been disposed of by the authority, my lord.
Yes,
in the general,
ought to have, in generally it ought to have been disposed.
generally.
But in case you are
No, I am fault, my lord.
period,
I am faulty. I accepted your lordship's view. But there is also fault of the authority also, my lord.
কি বলেন? Were rightly turned down by the authority. Stop. The petitioner made a third application before the authority on 20th April 2023 and the authority 2023 in respect of the single vacancy in the route Siliguri to Ranchi. Stop. Another application was filed in respect of the same route by the private respondent on 4th April 2023. Stop. Both the applications were taken into consideration by the authority, who, by a resolution taken on 18th August 2023, allowed the application of the private respondent only on the ground that it was submitted earlier and rejected the application filed by the petitioner. The private respondent was directed to produce the vehicle in compliance with the notification dated 7th June 2023 within 30 days from the date of uploading of the STA board decision in the website. Paragraph. It is submitted on behalf of the respondents that the private respondent has neither placed any vehicle, comma, nor fulfilled the requirements of the resolution, requirements set out in the resolution, set out in the resolution dated 18th August 2023 till date.
And no permit was granted.
No offer letter / permit has been granted in his favor by the authority. Stop. Paragraph. Upon consideration of the submission made on behalf of the parties, comma, this court is inclined to hold that the resolution impugned. What is your prayer in the petition?
Here is different. Supplementary affidavit is more.
It's for issuance of permit. This court is inclined to hold that the resolution taken by the authority on 18th August 2023 is not supported by adequate reasons so the authority could not have allowed the application filed by the private respondent only on the ground that it was filed prior to that of the petitioner. Stop.
Applying,
no other ground.
Applying fast in, fast out method.
Yes.
Applying fast in, fast out method.
Petitioner applying. That is not stated here, so I don't want to quote that.
It implies, my lord. It implies.
No other reason has been assigned by the authority for allowing the prayer of the private respondent or rejecting that of the petitioner. The resolution impugned, being devoid of any reasoning, is required to be set aside. Paragraph. Paragraph. Accordingly, the resolution taken in the STA board meeting on 18th August 2023 is set aside. Paragraph. The concerned authority, being respondent number
2,
being the second respondent here in comma, is directed to reconsider the application submitted by the petitioner dated 20th April 2023 and considered the reconsider policy. Upon you need an opportunity of hearing.
Yes.
Upon granting reasonable opportunity of hearing to the petitioner.
Animal vehicle has already been produced, my lord, your lordship.
Within 4 weeks.
Within 8 weeks, my lord, election is there is no board member is available. Mr. Bhattacharya also knows.
Election is not declared, so it should be before that.
Before that, my lord, there is no availability of board member.
Next board meeting, my lord, next board meeting.
Next board meeting, any.
Let it be 6 weeks.
Next board
My
meeting.
lord, next board meeting is the vague.
That will be a very vague order. We do not know next board meeting. Maybe after 12 weeks.
Next year, tomorrow also, I do not know.
6 weeks from the date of communication of this order, comma, in accordance with law.
Deep law applies.
Paragraph. The decision taken by the authority shall be communicated to the petitioner within a week thereof.
So only one line can be added, my lord. The petitioner's vehicle has been already been.
No,
already
that I can.
produced, my lord.
Not this application is
For this
concerned.
permit, my lord, vehicle is given item.
Authority
Vehicle was
consider.
produced in respect of the earlier permit of a
Maybe,
letter.
but for that permit, my lord.
Authority
So
will decide.
it cannot be included.
You
Let the
place
authority
before-
reconsider.
Yeah, you place before the authority with vehicle.
Especially
authority
because you are in a position to place your vehicle now, here and now. isn't it?
Yes.
Next.
May I get back the order?
और ये judgment गुलो फेरत दे दिया order को. There are 2 copies. You can take back 1 copy. The older copy was in the record. ওইটা একটা ফাইলে ছিল, যেটা গাথা ওটা ফাইলে ছিল, লুজ কপিটা ফেরত দিয়ে দিন ওনাকে। ওনার হাতে যেটা আছে ওটা ফাইলে ছিল।
We have filed the original copy of the report.
In which matter?
601.
1 minute. Bye. Yes. Served.
Just now.
Mr. Bhattacharya, just now. You want to go through this? Yes, there is your
Yes, Your Lordship. Your Lordship, there was a meeting which was going to be take place on 12th of March, Your Lordship, but this has been postponed, Your Lordship. It has now been fixed on 16th. I've got instruction that this and their matter is placed in this board meeting, Your Lordship.
When are we going to wait?
After the board meeting.
Follow yourself.
Lordship will file a report after the. Lordship, his matter is fixed before this board meeting.
The West Bengal authority is actually the answering respondent, I think, because they have refused to issue.
Yes, Your Lordship, but the
last letter, last annexure, your lordship, which fell from your
My
lordship.
lord, page 13 of the report that has been issued after the order passed by your lordship. And that is the first letter.
Your lordship.
That is the first letter issued by the ST West Bengal in response to the letter of the STA Jharkhand from 2019, my lord, till date.
Page 14 is of my report, my lord, your lordship. Can you see? Your lordship wanted to know whether we have given any reply to the Jharkhand or not, that we have given the reply. Earlier also have been rejected, now also it has been rejected. Page 14, annexure R4. My lord's observation was there, whether we have given any reply to the Jharkhand or not, is the reply.
Has been kept pending till order of the Honorable High Court.
Hey, your lord.
My lord, very limited question, my lord, involved in this matter, my lord. Whether the non-seeking of prior consent, according to clause 2H of the agreement, is the fatal to grant counter signature of the application. My lord, what has been allowed by the statute? My application for grant of counter signature lies in the for the portion lies in the West Bengal.
Supplementary.
So section 2, clause 2H is required, admitted position. But after the issuance of the after the grant of such extension, my lord, ST Jharkhand issued a letter for counter signature. Jharkhand, ST West Bengal from the very beginning of 2019 has been sticking to the point that no prior consent has been taken. Nevertheless, my lord, the ST West Bengal has referred that the application for grant of extension is illegal. Grant of extension is beyond the limit, my lord.
No, they only say violation of 2A.
Violation of 2H has not complied. But my lord, so far, my lord, application
of my repeating.
it is admitted position, my lord, that 2H was not taken, prior consent has not been taken according to clause 2H. But my lord, what is the object of the reciprocal transport agreement? There is the paramount consideration of the traveling public is to be taken into consideration, paramount consideration. To comfort, this is not a violation. This is a purely ministerial job. Obtaining prior consent is a purely ministerial job. Authority has to look whether the application for extension is within the limitation period or not. Limit only 24 kilometers. Within 24 kilometers, an extension can be granted at any point of time as per the liberalized policy of the government by law. The intention of the legislature is to liberalize the grant of permit. But my application is within 24 kilometers, only 18 kilometers. So there is no impediment in the eye of law for grant of counter signature of my application.
What is the Jharkhand authority deciding?
Jharkhand authority extended,
Granted, yes.
extended, thereafter renewed on such extended portion. But my only submission before the lordship, that whether the non-seeking of prior consent is
Why
fatal.
do you want to come back with a report? That I do not follow.
Your Lordship, with the report regarding the decision whether the permit can be granted without prior consent of the reciprocating state, Your Lordship.
My lord, your lordship kindly
We have
Permit has already been granted.
yes, it has been granted, Your Lordship. It has been renewed, Your Lordship. Now they have given a
counter signature.
they have given a representation to us कि it has not been signed by the reciprocating state, Your Lordship, by the West Bengal, Your Lordship.
But how will how can you help the petitioner? Because you have already written to the West Bengal authority.
Yes, Your
They have
Lordship.
turned down your request.
Yes, Your Lordship.
No, no, my lord. They have not turned down.
The report.
Now, my lord, pursuant to your lordship's order.
So now, as on date, they have turned down.
No, no, my lord. Do your lordship kindly consider this aspect?
Page 14.
In
Page
view of the
14.
above counter signature, my lord, what the STA Jharkhand prayed for after granting counter signature, that you accord consent. You give your consent. It may be post consent, but you give consent. Whether the grant of extension would be allowed or not, that has not been whispered. Only one point has been ventilated, has been uttered by the authority, that no prior consent has been taken before grant of counter signature. But my humble this is not a fatal. But section 780, subsection 3, section 72, clause 222II says that within 24 kilometers, an application for extension can be granted at any point of time. And agreement also says that.
Without consent.
Subject to counter signature.
That is a ministerial job. I am saying that your lordship, that is a ministerial job.
How can it be ministerial?
But why it is a ministerial job? The portion sought for the extension lies in the West Bengal. Whether that proposed extended portion is within 24 kilometers or not, that is to be looked into.
Can it be ministerial in that case?
That is to be looked into. But it is admitted position that it is beyond 24 kilometers. It is 18 kilometers only.
No, that is not the dispute at all. Dispute is 2H.
2A, whether post or prior. Admittedly, ST West Bengal sought consent, sought prior post consent.
Can it be a brazen violation of
Instead of prior consent, according to clause 2A. That is the only point. Your lordship is the court of equity, my lord. Taking into consideration the liberalized policy of the government of West Bengal.
Do you want to come back with a report?
Yes, Your Lordship. We have. I have not been served with a copy of this
Jharkhand has
report,
nothing
Your
to say, my lord.
But they have written a letter to us, Your Lordship. I have to get back instruction whether the letter has been replied or not, Your Lordship.
You have given the
I'll give you a short
No,
note.
this
Let them-
letter we haven't-
Jharkhand has nothing to say.
This letter
But
we haven't.
only I am
Prima facie, that is my view also.
only I am your lordship.
আমাকে instruction দিতে হবে।
Considering the provision under section 80, subsection 3, and the provisions under section 72, clause 222II. Well, my application, my lord, for grant of counter signature may be considered, my lord, without sticking at the, my lord, the post consent has been obtained. Short for. But it is admitted position that the post. It is the fault. 72 XXI.
Which one you are referring?
Motor vehicles.
My lord, first proviso. But admitted position 18 kilometers. There is no dispute.
This is not interstate.
My lord,
72 doesn't deal with interstate permits.
my lord, in agreement copy, my lord, in the agreement it has always said. In the agreement it has always stated.
Section 72 doesn't deal with agreement will be interstate, of course, reciprocal agreement.
72, my lord, stage carriage permit. Both, my lord, interstate, inter-region, intra-region, all are covered, my lord. All are covered. All are covered in the under chapter 5, my lord. Chapter 5 related to grant of stage carriage permit.
That is not.
As well as to contract grant permit. Agreement.
Violation of the 2H. 7222.
My lord, agreement, in the agreement, my lord, I have been covered, my lord. Also, my lord, the extension, my lord, for beyond 24 kilometer can be allowed. And section 80, subsection 3, my lord.
That is settled law. 24 kilometers is not the criteria here.
And my section 80, subsection 3, my lord, also.
Primordial issue is 2H. Primordial issue is 2H. 2H. That is a Rajan violation. And that I have stated your lordship as.
Agreement copy.
Here, the
Agreement copy.
reciprocal agreement is annexed to your repetition.
No, my lord, I'm submitting. এটা উড়িষ্যা এটা এটা দিন
In the
clause
earlier,
2.
in the earlier order, it is reflected, page 44.
Yes, my lord. Yes, my lord. That is not disputed, my lord. That is not disputed.
আমাদের একটু বলো ভাই ভট্টাচার্য,
হ্যাঁ দাদা
বলো আমাদের কোনটা কোনটা বলছে।
অবশ্যই
ছেড়ে দাও না, যা আছে তাই নিয়ে সন্তুষ্ট থাকো।
মানে clause H, my lord, your lordship page clause H, my lord. 2H.
2H আমরা বলেছি।
2H, my lord. What the ST West Bengal referred.
Subject to consent does not.
That is admitted position. I am not
does
on that.
not post facto consent.
But, my lord. But.
This is not the issue at all. Issue is consent. It should have been taken earlier.
My humble submission, my lord, my application is, my lord, proper application, appropriate application within the 24 kilometers. That can be considered, my lord, authority.
And the consent was to be taken by the issuing authority.
Yes.
Not by you.
Not my, no, that is no role on my part. That is the interest.
Let the learned counsel come back with, I'll give you a short date because this is a very short. You can take this. This is recorded.
Building without building plan, building has been constructed.
It's not a plan, my lord.
There is a provision for post facto regularization in that case.
Let us come back with it.
There will be no impediment.
Why will the petitioner suffer for a quarrel between both the authorities?
We are not. We are.
In my read petition, I have also annexed one copy, my lord, that in the self-same dispute, my lord, without taking consent of the STA Jharkhand, the STA West Bengal granted extension for the portion lies in the Jharkhand without adhering the clause 2H.
Page.
Yes, my lord.
Earlier occasion, I have stated.
Yeah. Supplementary.
Clean difference. The permit issued by Jharkhand as a permit issuing state, extension short for in
West Bengal.
West Bengal, that is reciprocal state. And the second thing which my learned friend is suggesting, that permit issuing by the Jharkhand state as a permit issuing state, and the extension has been given by the Jharkhand state.
That is within the state.
That is within Jharkhand state, not with the reciprocal interest.
It is within the same state. It is not interstate. Where is that document?
Yes, ma'am. My lord, page 21 is the order, supplementary affidavit.
রিপোর্ট দেবে তো
এখানে দেখা আছে নাকি?
তো যাবো
On the basis of this order, my lord,
Hmm.
The original route Gomio to Tata, Nowadi to Tata, has been curtailed from Nowadi to Gomio. Page 24. No, ঠিক আছে. This is the order, my lord. On the basis of this order, you lordship kindly have a look at page 50 of my writ application. Page 50 of my writ application.
Yes.
It has been allowed. But Nowadi to Tata original route, curtailment of route Fusro to Nowadi, and extension for Fusro to Gomio. Everything is in Jharkhand.
This is not interstate.
Yes, interstate.
It's all in Jharkhand.
Yes, interstate. Nowadi is in Jharkhand. Fusro to Gomio, all are extension and curtailment portion.
Extension has been given in the Jharkhand.
Yes, I developed that. Extended portion Jharkhand.
To give permission.
Extended portion Jharkhand. Permitting authority to West Bengal.
Yes.
So, my lord, 2H is required from the Jharkhand. Without taking 2H, my lord, it has been allowed.
Permit issuing authority has to be West Bengal. How can it be Jharkhand?
No, Jharkhand.
Permit issuing authority
West Bengal.
has to be West Bengal, not Jharkhand.
This will be clear. Let us come back with the report, not I.
If extension is granted by West Bengal, permit issuing authority also has to be West Bengal.
Yes, my lord. At developed line. You lordship kindly have a look at 50. No. Page 50 of the writ petition. This is the permit of the ST West Bengal.
Whatever you said in the writ petition, that is your pleading.
This is the ST West Bengal. And consideration by the ST West Bengal.
This is considered by West Bengal. Yes.
West Bengal. Well, allowed. Observing the above fact, members of the ST decided to consider the prayer of the Ombasuto for curtailment along with the extension on the interest to Nodi to Tata.
And the extension sought for in West Bengal, no need for any.
The route of extension is in Jharkhand.
In Jharkhand.
So 2H is applicable.
No, my lord.
Permit issued by West Bengal.
There is difference, my lord.
No.
Your lordship kindly see the, my lord.
Page 50, page 50.
That is, my lord.
Page 50.
Page 50 of the writ petition.
One from Dumka to my.
Page 50, not that. Page 50, discount. Page 50 of the writ petition.
My lord, I'm coming.
Page 50 of the writ petition. 50. I am referring this one. And my lord, timetable, my lord, page 24 of the year.
Your lordship kindly come to my report, my lord.
Page 24, your lordship, page 24.
Your lordship kindly come to.
But page 24 of the supplementary affidavit, timetable has also been allowed. Supplementary affidavit, page 24.
Your lordship kindly come to my report.
Yes.
What Jharkhand authority has made a some defect, some fault. ওইটা কথা বলে নাই গো নডিটাটা কথা বলেনি কিছু
Yes.
নডিটাটা কথা রিপোর্টে কিছু বলেনি
আর ওটা তোমার প্লিডিং এ তুমি নিয়েছো।
প্লিডিংই তো নেবো
না নিয়েছো কিন্তু সেটা নেই এটা। Jharkhand come back to the report. Let Jharkhand say what is their stand.
My lord, your lordship kindly come to page 6, para O. It is pertinent to mention here in that in his letter, in his written submission, the petitioner has cited a different case altogether, which has no relevance with the present case of the petitioner. The case cited by the petitioner stated the counter signature of extension from Dumka to Basudida. That is the extension given in the
Nowadi to Tata.
State of Jharkhand. In respect of, my lord, License number, my lord, 84/28, my lord, permit number. On the route Dumka to Kolkata.
It was an in-between extension, you say.
It is meeting dated 11.
Different, that is different one, not page 50. Not for page 50.
This is what I am submitting, my lord. My lord is trying to confuse the court.
No. Learned counsel is referring to some other case, not this case at all.
Yes. He has stated that is not before me, my lord.
Come to page 50, please, of the writ petition.
Writ petition page 50. Route Noadi to Tata.
আরে বাবা তোমাদের অরিজিনাল কোথায় ছিল?
আমি কিছু অন্যায় চাইছি না। একটা এসটি ঝাড়খণ্ড কি ভুল করেছে সেই ভুলটা নিয়ে আপনারা চেপে বসে আছেন।
ঝাড়খণ্ডে চালাও না।
So in that event, I have to take instruction.
In this case, the West Bengal authority granted the extension without complying with 2H.
Yes, please, please.
And the Jharkhand has accepted it.
Yes.
I will countersign, dear Lordship, kindly, page 24. Page 24 of my supplementary affidavit.
I
24 of my supplementary affidavit.
I don't know who has signed this, my lord. And my lord, whether
Here, my lord, Jharkhand
Your
authority is
lordship
here.
will file a report in this, your lordship. Kindly
Page
file a report.
24,
Page 24 of you have
supplementary affidavit.
genuine or my lord, whether this has happened.
What submission is being made, my lord?
You have to, my lord, take instruction in this matter.
My lord, this is the notified by the Jharkhand.
Jharkhand has shown a good gesture by signing it despite violation of 2H.
Yes, my lord.
So why can't
They
West
can do
Bengal?
that. They can do that, my lord.
So why can't West Bengal also show a good gesture?
If somebody did a mistake, the same mistake I have to do. It is not a rule.
This is not a mistake. They have shown a good gesture. Since
Good gesture.
Lordship, it's for public interest.
But
yes,
see, my lord, there is an agreement.
And-
There are clauses.
And what is the,
anyway, let me come back to the report. I'll consider because this is not the fault of the petitioner, isn't it?
We don't
It's a tussle between the two authorities.
Who has done the mischief, he has to suffer. That's why here my learned friend has been suffering, my lord.
Report in the form
my
of
lord, only one thing, my lord.
next day. Because let her come back with the report. Report in the form of affidavit submitted on behalf of the second respondent is taken on record. Paragraph, learned counsel for the fourth respondent seeks extension of time to submit the report in the form of affidavit as sought. Paragraph, let the matter appear under the same heading on 10th April.
10th of April, lordship.
Please file your report on the
I
next.
will.
Next.
Madam, may I file my affidavit taking exception to the report?
You have served a copy, Mr. Shamanto?
Well, I have started. Yes.
Yes, what is the matter?
Matter is, my lord.
This matter will not be finished with by 5 minutes. May not be. হবে না তো কিছু।
May I start tomorrow, madam?
Only 2 or 3 minutes are left, I
It will
think.
take time, some time.
Why don't you start?
Wait, start কর।
Start, please.
If I can, if we can.
Yes, yes, yes.
Yes, my.
My lord, in the writ petition, I have challenged the legality and validity of the notice inviting applications and it's a P4, page 48. for granting auto rickshaw permit on several routes.
Yes.
Under the RTA not 24 100. In reference to the publication of the notification number such and such dated 21st of March 2023 and 1894 dated 22nd of May 2023, Transport Department, Government of West Bengal, and subsequently notice was issued inviting applications by number such and such 24 runners. The RTA board was held on 8th of August 2023 and considered the applications which are deemed fit and directed. Further, the Secretary RTA not 21 to issue notice inviting applications for the following categories as per vacancy exists on the notified auto rickshaw route in Kolkata metropolitan area. Auto 1, 2, 3, and 4 categories are there, madam. But I have challenged this notification on the ground. And if your lordship kindly come, the government notification imposing total ban, page 41. Restrictions imposed on formation of new routes and issue of permits in certain cases, certain areas. Notification number 3438 WT dated 2nd of August 2024. But this is the notification issued in terms of the order of the Honorable Division Bench. Only your lordship kindly see, whereas the Honorable Division Bench presided over by his lordship, the Honorable Justice D.K. Seth of the Honorable High Court, Calcutta, by an order dated 21st of November 2023, GA number 568 of 2022, APOT number 83 of 2022, was pleased to direct the Transport Department, Government of West Bengal, that a committee be constituted to examine the position relating to availability of road space, halting space, terminus, extent of accommodation of buses in such termini, and such other related matters in connection with issue of permits to the transport vehicles vis-a-vis the prevailing traffic congestion and automobile pollution in and around the cities of Kolkata and Howrah, to enable the state government frame a comprehensive passenger transport policy for the city of Kolkata and its outskirts on the basis of the recommendations of the said committee. And whereas the said committee constituted by notification number 44WT70 dated 2nd of January 2004 of the Transport Department has submitted its report with recommendation for control of traffic congestion and vehicular pollution to the government in July 2024. And whereas the government of West Bengal in the Transport Department has considered the entire report and decided to accept the recommendation of the said committee for better control of traffic congestion and reduction in automobile pollution in the city of Kolkata in the interest of citizens. Now, therefore, in compliance of the aforesaid order of the Honorable High Court and in pursuance of the power vested upon the state government as per provisions of the Motor Vehicles Act and rules, when thereunder the governor is hereby pleased to direct the State Transport Authority of West Bengal and all the regional transport authorities in the state that 1. No new bus route be formulated and permits be issued which may pass through the central business district, the Esplanade and Bandstand in Kolkata and Howrah stations and approach areas of Howrah Bridge in further orders. Number 2, no new permit of stage carriage shall be issued which may originate, terminate in Esplanade and Bandstand in Kolkata and Howrah station. 3. No new bus route shall also be created, formulated in Kolkata and Howrah without creating any appropriate parking space having requisite amenities for both the passengers as well as the transport workers. Number 4 is very relevant. No new permit shall be issued for auto rickshaw operating within Kolkata metropolitan area. Area in question lies within Kolkata metropolitan area. I have taken this challenge, taken this.
How are you affected? What is your locus?
Locus because the government notification supports me. I am governed by it's a division bench order, law declared.
So isn't it a public interest litigation? Isn't it a public interest litigation?
No, public interest litigation, but still then, my lord, I am affected.
When the government has taken, in terms of division bench order,
You are
when
affected
notification
not
has been issued.
personally, you're affected as a member of the public.
No, I am the operator. I have a representative challenge.
Which route? You are the operator.
But these are the new routes, all created. But the notification itself is a contrary.
How are you affected? How are you personally
Because I am affected because the government banned the grant of permit.
That is
Whether in violation of that government order, whether in terms of division bench order, the government can violate and issue the input notification. This is the question to be decided by your lordship.
this can be challenged in a public interest litigation.
No, my lord. Your lordship has jurisdiction, is my humble submission.
Please show me that you are personally affected. Your route is affected.
My lord.
Please show me that your route is affected. Your personal.
Same route,
affected.
my lord.
What is your route? Where have you?
Your lordship can see my route. Even the auto rickshaw cannot be registered in after 2004.
What is your route?
My lord, I have come before lordship against the illegal operation.
Answer to down, Judge. What is your?
I am answering in my own way. My lord, I am affected because of the illegal operation. My lord, notification is issued. It is dated, my lord, 8th of August 2023. And I came before lordship court against the illegal registration of vehicle. I mentioned paragraph 2. Fake registration, no registration at all. Without permit. I have given the entire numbers.
The only issue is no new permit will be issued for auto rickshaw operating within Kolkata municipal area.
If the permit cannot be issued, vehicle cannot be registered. After 2004, there was a total ban. Within KMA, no new registration of auto rickshaw can be made unless the government notification dated 2004 is relaxed or by the division bench order is modified by the Supreme Court. There is a binding effect.
Let us hear Mr. Sen, because I have a feeling that this is.
I shall not take more than 10 minutes. Not more than 10 minutes, but subject to my not to interrupt by my.
So will you please come back on the next?
My lord. No, only thing, lordship, that's today for my lord's satisfaction. My lord, the only issue is as per the prayer of the petitioner. If your lordship, my lord, kindly come to the, just my lord, but for my satisfaction. Prayer is, my lord, that challenging that particular invitation from the public for, my lord, the grant of permit. That is the challenge by the Barasat RTO. That means if there is any vacancy or if the authority has any authority to grant the permit, if it is not barred by any law or by any notification, then they can issue the permit. This is the only issue. Unregistered, registered, unauthorized, flying, other thing, those may be the averment, but not the issue. Now, my lord, my learned friend, my lord, just, my lord, he has drawn your lordship's attention to that 2004 notification, where that, my lord, embargo is there, that no new permit should be issued in KMA area. Now, my lord, my learned friend knows it very well. When I have annexed this document to my affidavit, he should have, my lord, drawn my lord's attention also, because we are the, my lord, the officer of the court. Lordship, kindly come to page number 49. Page number 49.
Of your affidavit?
Yes, lordship. Not more than 5 minutes, Mala. I shall not take. Very good, very good, very good, very good.
49.
Page number 49. Now, my lord, in order to, my lord, to mitigate the problem that after that notification, my lord, that 2004, today we are in 2024. Now, my lord, in 2018, my lord, the authority thought it fit that a fresh notification should be issued.
Oh, this is omitted?
Yes, this is the notification of, my lord, the December 2018. Now, lordship, kindly see the language.
Yes.
No new permit shall be issued for auto rickshaw operating within Kolkata metropolitan area shall be omitted. Now, my lord knows that as per the General Causes Act, possibly, my lord, section 22 or section 23, that the authority which has power to issue the, my lord, notification circular has power to issue, to modify, withdraw everything. Now, this was done. Now, my lord, this came up before this Honorable Court, challenging the, my lord, because, my lord, there was, after this, a new auto policy was, my lord, framed. That was in 2018. Let's kindly have a look. The next page 50, a new auto policy where it has been specifically mentioned that that particular embargo there is not there after that notification, modifying the earlier notification. And that new policy of 2018, that was challenged before the learned single judge, before this court, that is at page 53. And the learned single judge observed, and practically, my lord, it was the findings that it's a policy to regularize some unauthorized flying of auto rickshaw. It's a policy. There is no question of any interference. And, my lord, kindly, then matter went up to the division bench. Now, my lord, kindly come to the, my lord, order of the division bench, challenging that dismissal of the writ petition by that operators. Now, page 58, Lordship, kindly come to page 58. That order of, my lord, the coordinate bench that was challenged before the Honorable Division bench. Now, Lordship, kindly come to page 58. Page 58, and, my lord, kindly come to internal page 2, page 59. Now, my lord, at the middle portion, just after the first paragraph, by another, all right, my lord, kindly come to the first paragraph of that page 59. By another notification dated 18 December 2018, the following was deleted from the earlier notification. No new auto rickshaw permit should be granted in routes and area falling within the jurisdiction of Kolkata metropolitan area. The impugned notification was published on the same day. The appellant is aggrieved by a particular paragraph of the notification, then subsequent as follows. And, my lord, kindly come to, this is the, my lord, the division bench order. Let's kindly come to internal page 3. My lord, first, second, third paragraph. We are of the opinion that in order to prevent misuse of discretion, proper guidance and directions are required from this court. That means otherwise it is okay. Now, what the guidance and, my lord, the further direction, we direct both the notifications of 18 December will be implemented by the government by using their discretion reasonably, fairly, and without practicing any malicious discrimination between the new auto rickshaw and unauthorized auto rickshaw. That means, my lord, the court say that according to your policy, since you have stated that in several routes there is a cap, 50 permits, 60 permits, then why only to regularize the unauthorized, my lord, the permit, the plier of the vehicle? But if fresh applicants come, some percentage be also be kept set aside for them. So accordingly, my lord, after that, and this, my lord, this policy was for a time frame policy. This 2018. Then, my lord, kindly come to, my lord, the page 64. A new policy, then, my lord, has come up. After that, almost on the, my lord, the same, my lord, the all those points are there, except only thing that the division bench, my lord, that observation was, my lord, looked into and considered. So after the notification, after having been amended in 2018 December, then nothing remains so far as allegation is concerned. So our prayer is only to this extent. Scope of the writ petition is this, that the Barasa Authority has no power because of this embargo in 2004 notification. When embargo gone, then nothing remains. And, my lord, elaborately, my lord, everything has stated in this affidavit.
Nothing.
In my humble submission, my lord, the order of the Honorable Division bench, under which the notification was issued.
Notification has not been challenged on that ground till.
What is your
I have challenged the notification on that ground only. Whether the order of the Honorable Division bench can be modified or varied. Well, kindly see, this is the only question to be decided. Whether your lordship would be deciding. Well, kindly see page 41. When a notification has been issued in terms of the order of the Honorable Division bench,
whether that order of the division bench can be modified or varied by another division bench.
It carries the seal of subsequent division bench when the matter went up to the
I did
division
not
bench.
start,
Have you challenged that?
my lord.
Have you challenged that variation?
Yes.
Where is it? Where is the challenge?
Your lordship, kindly see my affidavit, my taking exception.
No, your prayer in the writ petition. Exception cannot challenge a verification.
Well, I challenge them because they took this point in the affidavit. I have dealt with my reply. Well, kindly see the reply. Kindly see. I have dealt with specifically on that ground. Neither the state nor any court, my lord. Only the Supreme Court can vary the order of the Honorable Division Bench. Division bench having same strength cannot vary the order of the other division bench.
You are challenging the division bench.
I am challenging the
The
notification.
authority of the division bench. No.
I am challenging the notification on the ground.
Notification was varied by the second division bench. You say the division bench could not have done that.
It was not brought to the notice.
You have to go before the Supreme
No,
Court.
no, it was not brought to the notice of the division bench.
Let us not spend more time on this. Come back on the next day.
Madam, this was not brought to the notice of the Honorable Division Bench. There is a division bench judgment.
Shall I make it not today only? Is it
No, my
very
lord,
short?
kindly, my lord, the recorded that heard the parties and my lord, the matter be listed for orders on any day or any other, my lord, the caption. I leave it to your lordship.
Heard learned counsels for the parties. Paragraph.
My
Let the matter
affidavit
let-
has been filed. Your lordship can record that.
Yes, yeah, exception used by the petitioner. Exception used by the petitioner to the report in the form of affidavit submitted on behalf of the respondents is taken on record. Paragraph, heard learned counsels for the parties. Paragraph, let the matter appear under the, let it appear as for orders,
For orders, my lord, for orders,
because I've heard it extensively.
my lord.
Madam,
Appear under the
hearing is
for
required.
orders.
Madam, your lordship, I make it clear. I shall be taking some time, my lord.
You take time.
I shall be taking some time.
The time that the court grants.
Madam, maybe, but still then because I have come to your lordship court, my lord.
For orders. ঠিক আছে? On 9th April.
My lord, my lord.
দিদি,
Get
এটা গ্রুপ 7 এর ফর
Orders.
অর্ডার্স থাকবে কিন্তু। গ্রুপ 7 এ ফর অর্ডার্স থাকবে সকালে না। ব্র্যাকেটে গ্রুপ 7 সেকেন্ড হাফে ফর অর্ডার্স থাকবে।
Well, I had finished my argument in rejoinder. I had given my notes. They had taken twice. They had taken time to deal with two new judgments in the notes. If they can fit, or I would humbly request Mr.
My lord, I have talked to the London Advocate General.
to give his note.
My lord, you will know more.
Is the Advocate General's presence
Yes.
required?
No, no, no.
No,
Here, this is
Advocate General is leading me in this matter.
no, he's
We have-
saying that no more is required.
Busy person, you can continue.
Yeah.
This was the matter where
My
I
lord,
was
may
lower
close-
state.
My lord may close the hearing because we have finished our argument.
Yes.
Only two judgments he wanted to cite, my lord. I have talked to him, my lord. That he told me that
Not today?
not required.
Not
Not required.
required. Not
Not
required.
required. My
Not
lord may
required.
close it.
Also, I can reserve it for judgment.
Yes, yes.
Yes?
This was a much lower state. I mean, here I wanted, give me the penalty. I'll give the penalty. Here, without giving me the chance to pay the penalty,
yes.
you straight away came and cancelled it. And for that, I am relying upon my lord's judgment and the division bench which they placed, where the policy was to offer the penalty first.
That is from the bar.
That was
No,
the judgment record. Yeah, no, original bench, division bench record. I have referred to in my note.
Sir, my lord will decide. We have pleaded and argued.
Argument concluded, judgment reserved.
Thank you.
Didi?
It's better to close it.
Thank you.
I beg to favor the petitioner, my lord. Affidavits are complete in this matter. The petitioner has, I'm led by Mr. Shomo Mojumdar in this matter, my lord. Kindly allow me to place, my lord. He will come and take over.
Respondents?
But I am for the respondent ADDA. They are the effective respondent because the claim is against my lord ADDA. But I am led by Mr. HON'BLE Basu. It becomes.
The state also should be there.
No grievance against state, my lord. ADDA has not imposed a conversion charge, which we say that legally there's no provision for such imposition. It's illegal beyond the statute. That is the challenge. So their action is under challenge.
Time পাওয়া যাচ্ছে না।
কি বলছে?
No affidavits.
Lord, affidavit was called for. They have used affidavit, my lord. And I have also not given my reply. Lord, I'm filing my.
You have used
Yes,
affidavit.
Yes, my lord. It has been served and
Report
have been
in the
exchanged.
corner.
No. এমনি affidavit দেওয়া হলো। পরে তারপর বলবো।
Have you received a copy?
Opposition we have received, my lord.
No reply is required.
চলে গেল। Lord, reply. The report, not we have used a reply.
This is a comprehensive affidavit in opposition.
My lord. Well, initially there was a direction to file a report.
Then it was
My
shifted
lord,
to an
because a
affidavit.
point we have raised a point of maintainability that this is not a simple case of, my lord, transfer. Rather, this is a case where the petitioner has actually asked for development. They want to actually make a, my lord, the cooperative society, they want to erect an apartment. That was not allowed. Against that order, my lord, they had applied for a review of that decision. That was also, my lord, disallowed. Now, this was in 2017. Now, in 2011, perhaps, this writ petition, 2022, they have filed this writ petition challenging that order, which is actually appellable under the West Bengal Town and Country Planning. The point of appeal, we have satisfied your lordship, my lord. This matter was heard on several occasions on the point of maintainability. The maintainability point is satisfied that this is not an order under section 46 or a development order. Your lordship, my lord, directed that the matter be heard on merit. Point of maintainability was kept open. So it has to be heard on that. But my lord, so far as the report is concerned, we have used exception. But the my lord, opposition, no reply is.
Do you want
May I get 1 week's time to give point of maintainability was kept open and Mr. Basu submitted that he wants to, he's not shying away from the allegations. He says that he said that we are not shying away for the allegation. That is why we'll file an opposition to it. That was our contention.
Let him come back with the reply.
Reply,
Should have been exchanged in the meantime.
it was exchanged, my lord, I believe. But we have served our opposition.
Affidavit in opposition submitted on behalf of your respondent number.
Opposition reply. My lord, we are respondent number. Opposition.
Two, on behalf of the second respondent is taken on record. Paragraph learned counsel for the petitioners seeks to use a reply to the affidavit. Was anyone appearing for the state also? No.
State, nobody appeared. We shall give another notice to them, my lord.
No, Mr. Dev was appearing.
He's in court now 654 now. Because they are now taking book money is being taken.
Please inform him about the next date.
I shall
Mr.
inform.
Dev is appearing.
I'll pay for 1 week's time only.
He may not be using an affidavit, but then he should be informed.
No, because the stake is entirely on
Yes,
ADDA because they have charged.
Let the
1 week.
matter appear under the same heading. On 8th April,
8th April. The same position, my lord.
same.
Same position.
Next.
Lordship, in this
I
matter,
appear for the petitioner.
Mr. Nobukumar Das is appearing for the respondent. Due to some personal problems, he has left for the day.
Affidavits are complete.
Yes,
Everything
yes,
is
my lord,
complete.
Lordship may remember, I will not oppose, but this is one of the two matters who have,
Next witness.
I have kept on mentioning because my lord, my possession has been taken over. My lordship, I can't, the adjournment is being sought for, kindly fixing next one because my lord,
Week will not be
But my
possible. Just 1 week in this.
I understand, madam. I'm without my land has been resumed by the government. The post board has been set up without serving me a notice.
Very well, 3rd April. There's a holiday.
No, I understand. And may I file my affidavit in reply?
Reply, very well.
Lordship.
Affidavit in reply submitted on behalf of the petitioner.
Article monthly.
Record.
Full.
Paragraph. On prayer of the respondents, the matter is adjourned. Paragraph, let the matter appear under the same heading on 3rd April.
My lord, this was item only made retain his position.
It will hopefully.
I'm deeply. Poretta. Key name poretta call?
Pending matter will come up at the top.
3rd April. Obligation. 839.
My lord, I appear for the petitioner.
কোনটা
839. Indranil Chaudhary.
না না না
My lord, I appear for the petitioner. But again, a case, my lord, wherein the possession of the land has been resumed by the government. So this is the affidavit. Well, Mr. Amitesh Banerjee was opposing appearing for the.
Should also not exchanged, I think. In this
I'm
matter.
sorry, madam. Mr. Amitesh Banerjee along with Mr. Tarok Karan. But affidavit exchange, I filed my reply. Affidavit exchange long back. Well, may I inform you the gist of the matter?
They are not there in their absence. Will it?
It will not. It will not. This again, my lord, my position has been resumed.
Will you inform them? The same date.
Very well.
Yes.
Very well. Last week, Tarok Karan na take.
Or will you come back the week after that?
But kindly keeps it on third. At least, even if Mr. Banerjee is not there, I can put pressure on Mr. Tarok Karan to come.
Affidavit in
But I
reply.
tell your lordship, actually, what happens is, I know even if some position steps are taken, I can always come back before your lordship and mention. But my lord, it is difficult to make the clients understand because they are without the position for years now.
I understand. Affidavit in reply submitted on behalf of the petitioners is taken on record. Paragraph done appears for the respondents. Paragraph, let the matter appear under the same heading on 3rd April. Please inform them.
I will. I'm deeply obliged. Let both the matters remain in the same position.
It will appear 2019 matters. So I don't think. Yes.
I'm deeply.
I am for the petitioner, my lord, last occasion, my lord, on 6/3/24. I have also, my lord, served the notice of the petitioner and the, my lord, state advocate that the matter is appearing before your lordships. My lord, itself, my lord, by taking till now no reply, by taking the same cause of action, private respondents, by taking the same representation, my lord, the petitioner filed 3 writ petition.
They are not interested. It will be dismissed. None appears for the petitioners. Petitioner. No accommodation is sought. Your Honor, dismiss for default. On the last occasions also, they did not appear.
Yes.
Only private respondent or number record. Respondents.
Respondents are not here, my lord. I pursuant to the direction of my lord, I served notice, my lord, with mention also I am with notice, my lord.
Who is appearing?
Orko Naki is appearing, my lord. Lord, again I will serve a notice and I do, my lord.
How many times you will serve notice?
Private response.
May it please your lordship, my lord, this is that matter, my lord, where no one is choosing to appear. My lord, this is that matter where question came up from the court Jalpaiguri, whether it should be Jalpaiguri or whether it should be heard by your lordship.
That
Now this was solved. Now your lordship intended fresh service, everything done. They are proposing to avoid the court. My lord, innumerable times, my lord, kindly requests, my lord, one order of personal presence of any, even a, my lord, inferior police officer, my lord, would suffice. They will immediately rush to your lordship's court. I am not talking about the SP. My lord, they have blatantly given a complete go-by to the order. They have, my lord, raised the construction to the ground. Despite, my lord, an order made by your lordship's court. My lord, I put this question to myself, my lord, how many times I'm going to, my lord, request Mr. Orkonag and Mr. Shishano Bandyopadhyay to, my lord, enter appearance. If they choose not to appear, not to give any priority to this matter.
Second May order, which was not communicated.
They have used an affidavit.
Pursuant to the 2nd May 2023 order, advocates were appointed, state advocates.
No. No one entered appearance. My lord, Justice Sen's order kindly cease.
I'm talking about Justice
Yes.
Sen's order.
Thereafter, my lord, no effective steps. And my lord, kindly looks into the nature of the order made by your
Where
lordship's
do you
court.
get the names of the advocates? You've just named two
Yes, because they were representing.
earlier.
Yes. And my lord, Justice Sen's order, my lord, entirely kindly reads it.
Anyone for the affidavits are exchanged?
My lord, yes, Mr. Nag has used an affidavit on behalf of the respondents 1 to 9, on behalf of the Ranjan Kumar Das,
File your
Subdivisional Officer Jalpaiguri has filed an affidavit.
You
Reply
filed your
also
reply.
yes.
Any state advocate today here? I'll appoint somebody. I do not find any of the group 1 state advocates. Only not today.
Monday, my lord, let me take my chance.
Yes.
My lord, your lordship, my lord, is it your lordship's desire that he once again informs the GP?
Nothing, not necessary. I'll appoint because it has been indicated.
Very well. Monday, same position.
দিদি এটা not today করুন।
Umidda আছে? Mr. Pan is here.
For the state, someone has to give. Generally, Mr. Bandyopadhyay, I do not find any of them today, strangely.
Monday, let me take a chance.
I find 900 persons in the panel. In the civil and 900 persons are in the panel.
Now all are in 654.
All. Good.
All are in 654. What is happening in 654? 642.
My lord, I appear for the requiring body KMDA. State is the.
Today, my lord, I have no other option, my part. Then I have to make a substitution immediately.
This is very strange. Generally, there is.
I have concluded,
I
Mr.
find
Kalkar
Mr.
concluded.
No, I have not concluded. I have not opened even.
Learned counsel is. Yes, learned counsel standing behind you. He appears for
No,
the
only
state.
hard. My lord usually records that.
He appears for the state generally, I think.
Here, Mr. Mr. Bandyopadhyay,
Mr. Bandyopadhyay,
Mr.
Mr.
Bandyopadhyay,
Bhattukar, everyone is there. Where are they?
I have no other option but to file a substitution application very shortly. All are serious. And not a single demand. Can you see? At least I have 3 orders of your lordship where my lord state prayed for accommodation.
সেটা টাইম চাও বলো
I'm fully covered by the judgment of your lordship's court and by Justice SUVRA Ghosh's order is covered. Very short.
KMDA has made his submission. You have also made your submission.
Yes.
I've taken notes of it.
Yes, I know that. And that's a
It's for
reminder.
the state to, yes.
Only to state to indicate.
Only, my lord,
তুই আরো
I
বেশি
think-
বলতে চাইলে বল কিন্তু but he has concluded. If you want to,
has he concluded?
He has
You will
concluded.
I have concluded, you have concluded.
Your
The recording
submission
is
is
there.
also recorded.
অন্য বাবলা সে গুলি ফেলেছিস।
That
Concluded
is.
and forgotten.
Concluded and forgotten.
Tell us,
But-
this is the order.
But state has not made any such.
Shall I make it only not today? Will you please bring the state on
My lord, I request your
Monday?
lordship, give me 10 minutes time, keep it as 4 orders. More than that will not be taken. Can you see this order of your lordship? It is covered.
No, I'm not shying away from hearing, but then will
No,
it
that I
really
know.
suffice?
Paragraph 3 or something.
এই কপি দিচ্ছ না তোমরা আনরিপোর্টেড ইস্যু করছো
Okay,
দাও না
paragraph 3 and 7. Same thing. This now it is decided by Justice Tandon that is taken up without any acquisition. That finding is there. Thereafter also, my lord, it is not. We are not getting anything. And 17, my lord. What a poll.
That's why I say if you can, you are appearing for the state.
Mr. Bondrote is in code number 654.
What is happening in 654? Everyone is 654. Mr. David,
In 664, land matters taken up from 2 people. All are hearing matters, including
also
motions.
now this is difficult. Some have to be
Yes,
here.
that's true.
Some of the councils should be here.
My lord fixes any other day, and I will also consider this judgment passed by your lordship.
I propose to make it not today only because I would like to see the face of the state.
Not today only, my lord. No, what I'm submitting, my lord, subject to my lord pleasure. Kindly give us a date on that date. Give notice in writing and keep in your lordship this on that date. If it does not come, kindly conclude.
And in that event, some documents, my lord, and relied on by the state, I may be allowed to, since we have.
Opposition reply conclude.
No. I want to place some documents annexed with the state's affidavit, already on record.
You want to re-argue?
No, not re-arguing. If the state does not.
If the state doesn't, we want to help the state.
Do whatever, my lord. Get rid of this matter.
Since we do not have the clashing.
For the state respondents, stop, no accommodation is sought. Paragraph, let the matter appear under the same heading on, when will you come back? 10th April?
As early as short possible, my lord. You lordship have heard this matter.
Because first week of April are fixed quite a few matters.
You, my lord, find any difficulty in this matter, do it more than 10 minutes.
I understand, but I have to hear of the matter. When 8th April?
8th April at 3:30 subject to my lord.
8th April, একটা line add করুন. It is made clear that the matter may be taken up for consideration on the adjourned date, even in absence of the state respondents. Please serve a final notice to them and I'll take it up.
We will.
Next.
Huh?
843.
Last occasion.
Yes.
Last occasion, my lord directed to file the affidavit in opposition by the respondent.
Is appearing. Appearances are not exchanged.
Yes, my lord, exchange and reply has already been filed, my lord.
Then what are you saying?
Today is the fixed for hearing, my lord. Kindly hard my case, my lord.
You are the petitioner.
He is the petitioner, my lord. I am the company whereby, my lord.
That's very, who are the respondents?
Petitioner, my lord, Soma Foods. Can you see the, my lord?
Affidavits are not on record.
No, that's filed, my lord. They have just served to me, my lord. I have filed.
They may have served, but it is not filed.
I have filed my reply.
Have you, where is your reply? You have not filed the reply?
It's filed for us. They have served the copy to me, my lord.
And where is your reply? Your reply is not on record too. Opposition on a reply only.
But they have served, my lord, I have replied there to my lord.
What is your reply? It is not on record.
WPA 14596.
You've not filed your reply.
My lord, at the opposition would be, my lord, in the record.
Opposition, they have not filed. You have not filed your reply also.
I think there is.
Affidavits are yet to be exchanged. Monthly list of May.
Kindly fix a date because my lord is pending for since long
No,
time.
record.
My lord, kindly fix a date. My lord, we have already, my lord, filed, my lord, that.
None appears for the respondents. Affidavits are yet to be exchanged. Paragraph, let the matter appear under the same heading on 6th May. Exchange your affidavits in the meantime.
My lord, kindly fix my top on the list.
I was shifting it to the monthly list, sir. Next.
My application.
Today, no respondents in the court.
This is the whole problem, my lord. Lord, we are waiting
I
for.
must speak to them, the learned counsels tomorrow. This cannot happen that all the respondents.
We hardly get any chance after 2-3 months. We are getting our turn.
There should be
And-
someone to represent the state here.
And my lord, here, my lord,
It's
is that
unfortunate.
both the matter has been assigned to your lordship, my lord, because my lord, in 2004, I have challenged the order of the competent authority as well as the appellate authority. Subsequently, my lord, it came to our notice that some section 3J, my lord, akin to section 17 of the Act of Metro Railway Act, required to be declared ultra virus. So accordingly, in this writ petition, I have prayed for the declaration for ultra virus of this matter. So, my lord, I was directed by your lordship to serve a copy as required under the law.
Affidavits have not been exchanged as yet.
They did not file in spite of the direction of your lordship, my lord. And this is the, my lord, the affidavit of service. I serve a notice upon the additional solicitor general, advocate, additional solicitor general, the office of the additional solicitor general. In spite of that, they are not appearing.
Who is appearing for the respondents in this matter? It's the union.
Item number 845, Lordship, I am appearing on behalf of the Respondent Union of India. Lordship, in this matter, I am led by Mr. Shubhankar Chakraborty.
Where is your affidavit of opposition?
Lordship, no direction was there to
What
file
he
it.
is saying. Very
645.
unfortunately, without going to the orders, he is making a submission like this.
Lordship, in this matter, I am led by Mr.
Kindly have a look at the matter order dated 5th of December 2023.
I've seen this.
For making any submission, one should know.
Yes, where is your affidavit in opposition?
And in presence of the presence of the union, this order was passed.
And here it's only the Union of India, not the state.
Yes, but this is only an union and the metro railway. Only thing so far that
That would be the same learned counsel.
same, my lord,
Lordship,
only
kindly
point
keep
involved.
the matter any day, Lordship. In this matter, I am led by Mr. Shubhankar Chakraborty, Lordship.
Please file your affidavit in opposition.
Lordship, Lordship, Lordship.
Learned counsel for the respondents. Affidavit of service. Learned counsel for the respondents seeks extension of time to file the affidavit in opposition as sought. Paragraph let it go out of list for the time being.
My lord, I will be the worst sufferer in this. When I tell your lordship why. Because admittedly, my lord, your lordship knows that I am entitled to the higher compensation. I am out of possession. They have utilized my land. Admittedly, my lord, without any basis, in spite of the law laid down by the Supreme Court, my lord, they have assessed the compensation on a basis of a document on an average basis. In spite of the fact there was the highest value was before the competent authority as well as before the appellate authority, they ignored this. But kindly fix up any date, my lord, since 2004. Kindly see, my lord, somehow I want to get rid of this thing.
Paragraph affidavit in opposition be filed within 2 weeks.
2 weeks.
Within 2 weeks from date, stop affidavit and reply, comma, if any, comma, be filed within a week thereafter. Paragraph, let the matter appear under the same heading on 22nd April.
In both the matters, madam, there are two
They're
matters.
together. They're running together.
Come on.
Lordship, kindly do not fix on
minutes.
22nd, Lordship. Mr. Chakraborty will not be there on the same date. 21st and 22nd, only these 2 dates.
So
Except 21st and 22nd, any day.
24th.
Lordship, Lordship.
Next.
This is my writ petition, my lord. I'm led by Mr. Mitro, my lord, till that I hope, my lord, he is able to join, my lord. I can start, my lord. These pleadings are complete.
Who is appearing for the respondent?
Mr. Gupta is appearing, my lord, for the
For WB HITCO is the principal answer respondent.
State is not a party.
State is a party.
The state is a party. I'll just check. I'll just check, madam. Yes, madam. State is a party. Respondent number 4.
Who was appearing?
But the principal, my lord, contesting respondent is WB HITCO. Because the impugned notices are issued by WB HITCO and also the agreement was with WB HITCO.
Yes, you had started on the earlier date.
Yes, it was started off, my lord. And in fact, in the meantime, Mr. Gupta didn't appear. So therefore, we had to give notices.
That was a one-off table.
My lord, this, if I may, my lord, since it was heard quite some time back, if I may recapitulate, this was a land, my lord, it was allotted in our favor on 2nd June 2006 for the purpose of IT and ITS constructing a building. The entire...
I understand the matter will continue till...
It will take some time.
My lord, if I start placing, yes, it may take 15 minutes.
So other matters, Didi, release kore din other matters.
Much
Other day.
Perfect. A brief background, my lord. There was an allotment in favor of the petitioner. In respect of the allotment, my lord, it was for the purpose of construction within a particular time of IT and ITS infrastructure. Entire consideration was paid. Now, allotment was followed by execution of a deed of conveyance in favor of the petitioner and in respect of the property. This happened in 15th of December 2006. There was, my lord, a requirement in the letter of allotment of completing the project within a particular time. However, when the conveyance was executed, it was executed as a freehold land without, my lord, and as an absolute transfer, without any restriction or without there being any form of covenant which would entitle them to repossess or resume the possession of the land in case of breach of any condition. Possession handed over in 2007. Thereafter, because there was some time for reasons beyond our control, mutation could take place only on 2012. Then we obtained, my lord, NOCs from various authorities and obtained a sanction of a building plan on 22nd of August 2012, and then thereafter construction commenced. We have, since 2014 onwards, started receiving demands for payment of compensation on the ground of alleged delay in completion of the project. We have replied to the same. We have specifically taken a stand that there cannot be, because it was a freehold transfer, then there cannot be a demand in respect of delay for compensation. Then in 28th October 2016, my lord, comes the impugned notice by which they had threatened to resume possession of the property unless the compensation is paid. This is the reason, this what has triggered the writ petition to be filed. Now, my lord, may I show the letter of allotment and also, my lord, thereafter the terms of the deed of conveyance. Because, my lord, my endeavor would be to show is that whatever, if at all there were some restrictions in the allotment, that was when a conveyance is executed and those terms are not specifically incorporated in the conveyance, then the authorities can't go behind the conveyance or can't ignore the conveyance and then take recourse to the earlier terms and threaten, my lord, threaten coercive measures against
Earlier
the,
terms meaning the terms.
yes,
in the
in the allotment. I would show, my lord, the conveyance is a complete freehold conveyance. So once that is executed, then there can't be at best, my lord, there can be an action on the basis of the terms of the conveyance, because the conveyance contain the final arbiter of the terms of between the parties.
Say the allotment doesn't merge with the conveyance.
Allotment, even if it merges with the conveyance, unless there are certain terms in the allotment which are otherwise repugnant with any term of the conveyance, then it's the conveyance which would, my lord, which would prevail, because that is the subsequent document between the parties, and the title is created on the basis of the conveyance. Well, 6 July 2005, my lord, is the letter of allotment. Your lordship will, my lord, kindly take your lordship to page 34.
Yes.
6 July 2005. There's an offer of allotment for application such and such. Action area ID so and so. We are glad to offer you allotment of 0.5 acres, that is 30.25 kathas, bearing plot number 18 to you on the following terms and conditions. May I place, my lord, these terms and conditions which were there in the offer? The total price of plot at the rate of rupees 2.5 lakhs per katha shall be rupees 75.26 lakhs. The payment of other financial terms would be as under. So these are the financial terms, my lord. There is no dispute in respect of this. And if your lordship, my lord, kindly turns over, my lord, clause Roman 3, the plot is to be used for IT and ITS purpose only and for no other purpose. That's one restriction which is there. Now, if your lordship kindly comes to clause Roman 8, you will submit the building plan through your architect to ED Estate Management, WB Hitco, within 3 months of possession of plot, and also complete construction of premises and area development on the said plot within 24 months from the date of approval of the plan. The time frame is expected to be adhered to, as otherwise the allottee of the plot shall be required to pay penalty as may be decided by the board of WB Hitco. So this is one restriction which was there in the offer of allotment, that within 3 months of possession, this has to be have to apply for a building plan and complete the construction within 24 months from the date of approval of the plan. Next. And my lord, with C Roman 4, my lord, just after Roman 3, physical possession of the plot and the deed of conveyance shall be executed on payment of full land price and delayed payment interest due, if any. So this, my lord, was the first. Now, my lord, if I
9 says freehold basis.
yes, and yes, clause
10.
10 says the plot shall be allotted on freehold basis. So allotment on freehold basis, that term was there, but those are mutually not, there's a contradiction, mutually destructive, rather, if I may say. Once you decide that you say it's allotted on a freehold basis, on the other hand, you say that there are conditions, you have to restrictions. But in any case, I'll proceed to the deed of conveyance subsequently, my lord. I'll show the terms of the deed of conveyance. These restrictions were not incorporated in the deed of conveyance. Now, my lord, if I take your lordship straight to, yes, page, yes, 36, my lord, this is, in fact, my lord, the entire page 40, which shows, my lord, the entire consideration which is paid. No, that's not an issue. So we paid the entire consideration on 19 June 2006 rather. And then, well, on 15th December 2006, the deed of conveyance was executed. After, my lord, we complete payment, that is on 19 June 2006. 15 December 2006, my lord, page 45. Your lordship, my lord, the deed starts from page 45. My lord will see the first page of the deed. It's titled the deed of conveyance. And then, my lord, the nomenclature just under the title, freehold IT. That's, my lord, the first description as to the nature of transfer which is taking place. Now, if your lordship kindly turns to page 48, internal page 4 of the deed. The third paragraph.
Yes.
If I may place, my lord, the third paragraph, it starts with, now this indenture witnesseth. Now this indenture witnesseth that in consideration of the purposes for which the land hereinafter referred to and mentioned in the schedule hereunder written is required by the purchaser, and in consideration of a sum of rupees 75 lakhs 50,000 and such, only paid by the purchaser, the receipt whereof the vendor doth hereby admit and acknowledge, and in consideration of the fact that the purchaser has taken inspection of such land and have satisfied itself as to the conditions and descriptions of such land, and also as to the amenities and facilities appertaining to such land, and as to the nature, scope, and extent of benefit or interest provided by the vendor, the vendor doth hereby sell, grant, convey, and transfer unto the purchaser such land more fully described and mentioned in the schedule hereunder written, to have and to hold the demised land hereby granted, transferred, and conveyed, expressed or otherwise assured or intended to the use of the said purchaser absolutely and forever. It's an absolute transfer in favor of the purchaser. Now, the lordship kindly turns to page 49. Now, what is, my lord? In fact, page 48, the second covenant of the purchasers toward the vendor. So what is the only restriction which was given? The purchaser shall utilize the demised land exclusively for its own use by constructing buildings thereon at the cost of the purchaser, in conformity with the planning area building operations rules 2006 and the planning area building operations regulations 2006 and other rules and regulations as prescribed or framed from time to time for Newtown, Kolkata, and according to plans, specifications, elevations, designs, and sections sanctioned by the vendor, and with the condition as the vendor may decide, and shall use the land and the structure thereon exclusively and wholly for information technology and information technology enabled services purposes, and no part of such building or land shall be used for any purpose other than IT and ITS. This was, my lord, the only restrictive covenant which was there in the deed. Your lordship, my lord, propose this. Lordship, may I take your lordship to page 50, the next page?
Yes.
It's after clause 12 is the covenants of the vendors. That is, my lord, the HITCO's covenants towards the purchaser. The vendor covenants with the purchaser as follows. The purchaser observing, performing, fulfilling, and discharging respective responsibilities covenanted herein shall peaceably hold and enjoy the demised land without any interruption by and from the vendor or its agents and representatives whatsoever. So, so far as the purchaser acts on the performs or fulfills obligations as mentioned, covenanted herein, that is the deed of conveyance. Till such time there is compliance of the terms of the deed of conveyance, the purchaser shall be entitled to be in possession and use the property without any form of interruption. The specific, I would say, my lord, this is possibly in the form of a negative covenant that my right or my possession will not be disturbed as long as, my lord, the terms of this deed of conveyance is being, my lord, performed, and it is nobody's case that I'm constructing anything which is not IT and ITES related. So, my lord, these are the, according to us, my lord, the relevant terms of the deed of conveyance, which now possession was handed over on 7th of March 2007. This is, my lord, is at page 55. This, my lord, for the records, my lord, and then mutation in our favor happened in June 2012, which is, my lord, at page 56. There's a mutation certificate. We started receiving NOCs, my lord, page 7 onwards for construction, and then sanction happened on 22nd August 2012. And if your lordship, that comes page 70 onwards, would show that we had already started construction at the property. The photographs, my lord, we have next page 70 onwards. So, subject to what my learned friend shows, there is, in my respectful submission, that restriction which, or rather the default provision which was provided in the allotment, in the offer of allotment that was given, that in case within 3 months of possession being given, I fail to apply for sanction, and then or within 24 months of obtaining sanction, I fail to complete construction, I'll be liable to penalty, and also if I fail to pay, then other coercive measure. That is not part of the deed of conveyance. In fact, I had commenced construction in the project. Now, 2014 onwards, 20th February 2014, page 74, my lord, will find the first demand on account of delayed payment. Yes, penalty for delayed delay in construction. In fact, there are several letters. Starts from, my lord, page 74, 20th February 2014, and there have been corresponding replies which have also, I'll show, my lord. May I, my lord, place the first letter of demand, because all of these are impugned till 2016. May I continue or come back on another day, my lord? Any date convenient to your lordship, my lord.
But only request apart from 27th and 20th.
Same request. We are at item there.
Will the court remain open on that? Because everyone is refusing a date on that. Those 2 days. Third learned counsel for the petitioner. Paragraph, let the matter appear under the same heading for further consideration. On 15th April.
Very well, my lord. Grateful, my lord. Deep.
In fact, when the calendars were out, this was the topic of discussion in the corridors.
Well, it will be my lord's pleasure to fix a time on 15, since my lord has started here. Immediately. Grateful, my lord.